Good morning, good morning, good morning, law nerds. It's Tuesday. It's June 13th. I can't believe it's like basically the middle of June. How is it basically the middle of June already? So, happy June 13th. We have a lot to cover today. So, replay crew, love you. All the timestamps will be down below. Most of what we're covering today is the second hearing in Idaho for the gag orders, cameras in the courtroom. On Friday, I covered the first hearing, which was with the Gonsalves family's attorney, Shannon Gray, and Judge, and then the prosecution and the defense. That hearing was like a 50-minute hearing. This hearing is like an hour and 30 plus minutes. So that is mostly what we are doing today, is covering that hearing and making sure that A, we give commentary, and B, we get to watch it together because I have not seen it yet. It has not been widely covered. I don't know. I think people or media thought that y'all weren't interested in all the things. I'm like, I'm sorry, you're talking about cameras in the courtroom. You have my attention. I want to talk about cameras in the courtroom. So that's the bulk of today. We're going to talk a little bit about Girardi because I've seen some confusion about what the breaking news yesterday actually means, and we'll talk about that first. And then that's what we're doing today. So I've got some new stuff to share with you. I'm really excited about it. I know the media thinks that we just wanted to see what the victim's family attorney has to say. And I'm like, I want to see this judge's attitude on camera in the courtrooms and this gag order, even though these rulings haven't come down yet. I want to know. And then I put this out to the members over on Patreon yesterday, and it seems that the vote has indicated which way they want to go. So I'm going to ask you for some content input as we decide what we cover on Thursday. So I'm going to ask you for that at some point. So get ready to vote. I'm going to give it a minute, but I will ask for that at some point during all of this to see if we add another new case to the docket. I don't have my screen pulled up yet to share. Delightful, because we're professionals here. So I'm going to do that while I roll the intro. All y'all, are you ready? Are you ready for the day? I'm ready. Let me know what you're drinking, when you're coming in, and all the rest of it. I'm finishing up a salted caramel cold brew. I've got a bunch of other water. You let me know what you're drinking, where you're coming in from as we roll this intro. It's so good to see you, law nerds. It's going to be a busy week. Let's go. Welcome to The Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. That wasn't the live stream intro. Don't tell anyone. It's already been that kind of a day. Can I just tell you real quick what kind of a day it's been? Here, this is what kind of a day it's been. This is how my morning's gone. I'm not even going to run the other one. It just is. It's fine. It's fine. We're professionals here. Look, man, people were like, Emily streams a lot. It's like, when people are like, I'm nervous to mess things up. It's like, no. It's a feature, not a bug. You're going to mess things up because we're humans and we mess things up. So this morning I get up. Look, I love to sleep in, but my kid has camp. Camp is a bit of a drive. Camp is far away. We're listening to audiobooks while we drive, but we're also chatting about the video game that he wants to develop and the difference between being able to like just directly recreate a video game that you like and making your own characters for a video game and telling story through a video game. And do you want to make it an app or do you want to make a console game? Like, we have a lovely chat in the morning, which I absolutely adore. So we roll to camp. Camp is forever away. And then there's drop off. Look, in Southern California, where I lived before we moved to Middle Tennessee, drop off was not like the Hunger Games. Drop off was like, some people drove and some kids rode their bikes and some people walked, but there wasn't like a process. I realize that the rest of the country has differences in drop off, but we have like drop off lines It is a procedure. You get emails at the beginning of the year to make sure that you know the drop-off procedure. God forbid you fuck up the drop-off procedure. That's a whole situation. But most drop-offs, there are 2 lanes. The cars pull up, you stop, kids get out. They go where they need to go. Once the kids are off and away, it is cleared. Cars move out, new cars move in. That is the typical drop-off procedure where I'm at now. So Megan asked a great question. Where I was in Southern California, there was no busing. None at all. None. Where I am now, there is busing. However, that is a whole nother situation because I have kids with ADHD and some sensory processing stuff. And the bus in the morning does not set my kids up for success due to the volume of the bus. Like my kids' cup gets real full with sensory stuff and the school day is real sensory. So we don't bus in the morning. But our kids sometimes bus home. My oldest is getting ready to drive. Anyway, so camp drop off is, no busing is a total thing in California. No busing is totally a thing. Where I was in Southern California, busing was not happening at all. You had to get your kid to school. Good luck. But there was also before school and after school care, but that was really difficult to get into because some adults have to be like physically to work and then traffic in Los Angeles is a thing. No busing is a whole situation. Anyway, so camp drop off is about the same as school drop off, or it's supposed to be. So this morning, there was one vehicle that plopped in the middle of the 2 lanes and then proceeded to do a whole morning routine, plopped in the middle of the 2 lanes. So no one else could drop off or get around. And I'm talking door open, like fixing their child's clothes, doing their child's hair, like wiping, like outside of the vehicle. Now, mind you, on both sides of this particular drop off, there's parking on the left and the right. So if you needed to park and get out and like zhuzh your kid and then get them off to camp, you could. But this morning, parent is out of the car, which is also a drop-off no-no. Parent is out of the car. Everybody's like, parents, stay in the car. Like, y'all are messing up. The kids know what to do. The kids have this down. This is, drop-off is like military precision. The kids know what is up. The parents are the ones that mess it up. So out of the car, doing an entire morning routine. And so the car directly in front of me, the woman gets out to get the kid ready, their kid out, and turns around and looks at me and is like, what is that? And I'm like, I don't know what's happening. But this is not the process. There is a procedure. So my kid is like, this is not where we get out of the car. And I'm like, I know this is not where we get out of the car. But do you see all the counselors coming to get you? It's because that car is not doing what they're supposed to do. So we can't do what we're supposed to do. And he's like, I'm supposed to be dropped off up there. I'm like, I know you're supposed to be dropped off. I have not had coffee. And my kid works really well on routine. So not being able to drop off where we're supposed to drop off is a whole thing. And I don't know if it's too early in camp that the counselors didn't want to be like, ma'am, there's parking right over there. But this is the same with like, I don't know, Costco. When you park your cart in the middle, like you have complete unawareness that there are other people that exist in the universe. And that is what this morning I was like, oh my goodness. Other people exist in the universe, and some of our kids have different quirks. So if your kid needs a little more time to get out of the car, I feel for you, mama. But there are multiple parking spots. Just go park. Just go park. Because my kid is like, but this is not where we go. This is not how we get out. This is not the procedure. Follow the procedure. What's the procedure? It's all happening. What is the procedure? And so the lack of awareness, all the parents were patient this morning. I don't know if that will happen in coming mornings. All of the parents were just like, because you never know what another parent is going through or what the kiddo needs. So they do an entire morning routine and they're getting their, like literally, this is going on for minutes. Zhuzhing the clothes, hugging, fixing of the hair, minutes. And then they leave their car to walk their kid to where they're supposed to drop off with the doors of their vehicle just open. And so they're in the middle and no one can get around on either side. And it is towards of course it's towards the end of drop off because it's me dropping off, not my husband, who, when they give you a half-hour window, my husband is in the first 3 minutes of that half-hour window and I am in the last 3 minutes of that half-hour window. So then the cars piling in behind me are coming in hot because we are at the last 3 minutes of the drop-off, and you can feel the panic of the other parents who don't want to be late to drop off. But nobody can go anywhere because there is this car stuck in the middle of 2 lanes with the doors open and no one there. And at this point, the woman in the car in front of me is just you can see her just doing this. And I am also doing this. And we're just no one has beeped. Because everyone is trying to just give grace because you never know what another parent is going through. But me, I am sitting there, how bad is it if I take off your door to get my kid to where they need to be? It's just and my kid was this is not where we drop off. I'm I know. We're just going to wait. We're going to wait till we can drop you off where you get dropped off. But the lack of awareness, SoCal people would have been out of their car yelling at this woman. This was a bit more of a gracious drop off today. I think midway through the week, it won't be. And because of the car that I have a megaphone on my car. So I am tempted, if this happens again, to turn on the megaphone on my car and just say, "Ma'am, this is not where we stop. There's parking to the left and the right. If you would please just take your vehicle to the parking on the left or the right. Everyone else can finish parking." And I feel for the camp counselors. I was a camp counselor. I feel for the camp counselors because at that point, they're just trying to get the kids out of the other cars. And they're but none of the camp counselors went up and were like, "Ma'am, this isn't it. You got to keep going." I'm sure they will get flooded with emails of other parents that were like, "WTF was happening this morning. Please tell someone to keep moving." Because if they don't know that that's the procedure, and I can't imagine you live here and have a school-age child and don't know, because literally that's the procedure everywhere. But being a camp counselor is hard. And so I get that the counselors are like, "It's still early. It's still early." But even a gentle, "Hey, there is parking over there if you need a little extra time," would have been fine. But yes, the white zone is for immediate loading and unloading of children. Their parents are uncaffeinated because it's early and we all have things to do. And this is a very far drive from my house. And I have to get to an appointment. And I want to get to Starbucks before that appointment. So I get to the lovely Starbucks because I found there are 2 between drop off at camp and the appointment I had. There are 2 Starbucks. I tried the other one last week. And the line to that Starbucks wrapped around the building, but also to the turn-in lanes. And it was absolute chaos. They had somebody from Starbucks out there directing traffic. And I'm like, "Oh, you do this every day. Because this is the one on the way to the 65. Okay, we're never doing this Starbucks again." So I went to the other one that does not have a drive-through. Much less chaotic because everybody wants to go through the drive-through. I get it. I don't mind getting out of my car and going in and looking at all the beautiful cups, grabbing my mobile order and walking back out. You don't even have to talk to people if you don't want to. It's great. So I get back into the car and there's a new Imagine Dragons song on that I love. So I start bopping along to this new Imagine Dragons song, Enemy. And I'm like, why do I know this song? I don't know. I swear I have, I don't, audio sticks with me. And I'm like, I have not sat in my car and listened to this song. I will forget what day my appointment is. Spoiler, it wasn't today. It's tomorrow. But I'm bopping along to this new Imagine Dragons song. And I'm like, I've never listened to this in the car. I haven't listened to this on my phone. Where have I heard this song? And I'm starting to be like, where have I heard it? Where have I heard it? Where have I heard it? Arcane. My child has been watching Arcane nonstop. This song is such a fucking bop. It is so good. I'm like, I'm going to start watching Arcane because of this song. So that is where I was like, oh, it's such a good song. So I'm bopping along in my car to Imagine Dragons. I get to my appointment. I walk in. I'm chatting with the woman at the front desk. She's lovely. She's back from maternity leave. We're talking about babies and how fast her kiddo's growing and looking at pictures. And then she's like, so you have an appointment today? And I was like, My calendar says I do. She's like, yeah, so I have you for tomorrow. I'm like, that tracks. I'm like, I'll be back tomorrow. I'm like, it's fine. It's on the way between my house and camp anyway. It's not like I left my house to come here. It's fine. It's fine. It's just fine. She's like, I'm sorry. I'm like, it's not your fault. You didn't put it in my calendar wrong. I clearly put it in my calendar wrong, but at least I put it in my calendar wrong the day before, not the day after. So here we all are together. And speaking of things that got done late, but still got done, we have our Pride stuff for you. We're going to swoop real quick so I can show you some of it, okay? Okay, Law Nerds. Pride did not get done last year because we were right in the middle of Deputy Heard and we didn't have the bandwidth on the team to do it. So I'm really excited to bring some new stuff for you this year. I'm excited we have a new giving partner this year that we are donating to. We have all new stuff. So let's just talk about that real quick. First of all, we are testing out bigger mugs. You've asked us for bigger mugs. So not only do we have bigger coffee mugs, like ceramic coffee mugs, but we have the 25-ounce double-barreled metal handle mug. I have big old paws. So this cup handle is super comfortable. You might look at it and be like, what? It is super comfortable. It fits a straw, but it doesn't have to. It has a fantastic top with all the bumpers so you can water it or coffee it. So this is one of our new Pride designs. I'm very excited. This is up on Law Nerd Shop right now. This is 25 ounces. I know some of you are going to be like, it's 40 ounces. It is not 40 ounces to freedom. I promise it's not. It is 25 ounces. When you are looking at size comparison, like here is your typical Starbucks mug. It is volume-wise about the same, but a little shorter. It fits in your cup holders really, really well. Maria said, that logo reminds me of Atari. There's a reason for that, Maria. We went with some familiar but different. Familiar but different. So this is our first one. I love this mug. I love that you can fit a straw in it if you want. I love that you can use it as a really easy leak-proof tumbler. Love, 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 love. Love, love. So I'm also wearing one of our new shirts. You don't always get to see my shirts because of how I sit, but shirt. I love our Law Nerds Unite shirts. This one is gradient. It comes on multiple different color shirts. We put shirts in the shop in light colors. Y'all asked. We did it. There are light colors. You can buy light gray and white if you want them. They're there. They're there on the shop. So I'm just going to show you what our new stuff is because I'm excited about it. So if you go to lawnerdshop.com, you can take a look at our new shirts, our new mugs. So this is our Retro Pride mug that I'm very excited about. We have shirts in Retro Pride. We have the Law Nerds Unite Pride. And then we have a few different varieties of the Pride flag mugs. We brought back the one that went into the vault with the red and the traditional rainbow flag. We also brought in the expanded flag or progressive flag for both the pink mug and the larger mug. So these are the XL mugs. So if you are looking for the expanded heart, you have them. I don't know if expanded is the right word. The inclusive, the upgraded, I don't know the right word. So we have the new, and then we have the one that is red with the rainbow heart that we released last year. And then we have the repeating Pride tote. I love those totes. They are super easy to use. So all is there for you. So if you want to go search by Pride, you can on the shop. If you just want to see the entire collection, you can search all products. You can search by type. So we have shirts, the bag, the mug, and then the additional mugs. All of the new collection here. Let's see if we can just go to the new collection. Where is our new collection? Me trying to navigate the shop. I always navigate it in the back end. Here, let's go by date new to old. That'll work really well. So these are the XL mugs. And so we added XL mugs in the different varieties. And then we brought in the pink mug this year. And we still have the retro one. I don't know where it went. It's around somewhere, I promise, with the red handle. Oh, because it was 2 years ago, so new to old is not going to do it. Emily, search your shop properly. I can you tell that I don't do sales things? I just tell you things are here. So we have, this is the historic that got retired Leonard rainbow heart mug for Pride, and then we did the pink one this year as well. So I don't know what happened with the stream health. Sorry, y'all. So there we go. So, have you thought about a glass water bottle? They are very, 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 very hard to ship. So yes, I have thought about it, but they are very difficult to ship. I froze. I'm back. Sorry, y'all. I feel attacked. We're talking about Pride and our stream goes down. Stop it. Leave us be. So you can search by Pride if you want to see all the Pride stuff. All the info is on the products, and that is what it is. So we have the large ceramic mugs and then this metal mug, the metal travel mug. All right. So that's there if you want it. Yay. And that will be up for a month. And we will, you know, we some of this stuff we might just make evergreen. We have not decided yet. But we could be convinced. Because, you know, law nerds are proud year round, right? So let's go to the quick bit. We have a quick bit, and then we're going to that hearing because we're going to be here forever if we don't. So let's do a real quick bit because I just saw a lot of misconceptions, and we need to clear those up real quick. Quick bit. All right. I saw a lot of confusion about what's going on with Tom Girardi. For those of you that are new to this story, let me see if I can do a quick road so far. Disgraced plaintiff attorney Tom Girardi, estranged husband because they can't get divorced because he's in a conservatorship of Erica Girardi, Real Housewives of Beverly Hills. There's no murder that's been accused, but it's very Murdaugh-y. Without the murder, lots more money stolen, it seems. Or at least what we know about the Murdaugh case. Because the Girardi case is in bankruptcy, and we're looking at over $100 million. A lot of that stolen from clients. Same type of scheme as Murdaugh. Same type of stealing, same type of clients, same type of audacity, same type of what the fuckery is going on. Girardi was an LA plaintiff's attorney. There's also, I think, a bit more, well, no, I can't say there's a bit more of that kind of taint of corruption with Girardi, because Girardi's like, I have the bench, I have this, I have that, and wasn't Murdaugh too? So as the house of cards started to fall down, Girardi immediately went into a conservatorship. The conservatorship is being governed over by his brother due to dementia. There has been a lot of conversation about whether that was convenient timing or whether that was going on or not well before. I'm not going to make a judgment on that. Dementia and Alzheimer's are horrible to go through as family members. To think that somebody might malinger that successfully to avoid responsibility is really fucking dark. Could it happen? Yes. But what's going on with the conservatorship and what's going on with regard to the criminal cases, because now there are 2 criminal cases, one in California, one in Illinois, whether he can stand trial for criminal purposes is different than him being in a conservatorship for the civil cases. So the standard for legal competency in a criminal case is different than the standard to get a conservatorship in California. Much different. And there is going to be a competency hearing. Girardi's lawyers, of course, are challenging competency, saying, well, he's in a conservatorship. He's not mentally capable of standing trial. The court is going to make this decision. Getting to a not competent finding in criminal cases is tremendously difficult. It is a very high bar. The prosecution and the defense both retained experts, and then their experts are going to present their findings to the court. The reason we know what the government's expert found is because the government filed an ex parte application for access to the unredacted expert report of Dr. Diana Goldstein. And we're going to go through that report very quickly. It's a very short report because this is where all of this information broke through both the LA Times and Law 360. There have been reporters that have been doing a great job staying on top of this story, and I thank them for that. Government's ex parte application. The government, by and through counsel, asks for ex parte, meaning the defense doesn't need to respond. We just need the court to decide that we get the unredacted report. As for ex parte access to the unredacted expert report of Dr. Diana Goldstein related to defendant Tom Girardi's competency proceedings. On a meet and confer telephone call on June 7th, 2023, counsel for defendant stated that they do not object to the ex parte nature of the application. However, defendant objects to providing the government with the unredacted Goldstein report and intends to file a response to this application. This application is based upon the attached memorandum. We're going to go through the memorandum real quick. Defendant Tom Girardi has been charged with numerous crimes in 2 federal jurisdictions related to his alleged embezzlement of tens of millions of dollars of client funds from the trust accounts of his former law firm, Girardi Keys. The reason this is tens of millions is because some of the loss they could not track all the way back, and some of the loss from the law firm is not just client loss. So we're looking at that much larger, much embiggened number in the bankruptcy. It's because there's not a direct correlation here. But in breaking down the criminal proceedings, we learned a lot of the depth that Girardi went to, more than we learned in things like The Housewife and The Hustler, more than we learned in other reportings. We saw how many clients and the types of clients that Girardi was stealing from and defrauding. Some of those have been proven. Some of those are alleged. The reason I say some of them have been proven is because some of them have been proven in civil proceedings. When we look at the Ruiz Gomez family, that's been proven in civil proceedings. They had a $12 million judgment against him because he stole their money. That's not alleged. That's a fact. That happened. Okay. Stealing tens of millions of dollars from client funds. The court previously issued an order governing defendant's competency, which required the parties' experts to provide written reports containing their assessments of defendant and determination whether the defendant's competent to stand trial. The government's expert neuropsychologist, Dr. Diana Goldstein, concluded her examination and opined, among other things, that defendant is competent to stand trial. Pursuant to the order and to alleviate any concern that the prosecution team would be exposed to any privileged information, the government proposed that Dr. Goldstein's report first be provided to the defense so that any privileged information would be redacted before review by the government. Meaning, if Tom Girardi is talking about things that he talked about with his attorneys, things that are attorney-client information, things that are not for the government's eyes, it can go to the defense first and they can redact out things that are privileged. But the government says the defense completed this review and applied significant redactions to nearly 10 pages of the report. Defendant's redactions are purportedly based on his Fifth Amendment right. Here's the thing. Well, Emily, keep reading. However, the defendant does not have a Fifth Amendment right against self-incrimination in a competency hearing. And that is the thing. Provided the statements are not sought to be introduced during the guilt phase. The purpose of the competency hearing is to see if this defendant can stand trial. It's not him waiving his right against self-incrimination because it's not being used against him to prove guilt. And it's pretty easy to cordon those things off and not use them at trial when they need to be used at a competency hearing, which is scheduled right now for sometime in August. And then they cite case law stating that there is no Fifth Amendment issue at the competency hearing. But they can't turn around and use it at trial and be like, well, he told the psychiatrist this, unless he does something to open the door down the road or waive that privilege down the road. but as a general rule cannot. But this does not mean he is competent to stand trial. This means the government expert says that he is. The defense will have an expert, and then the court will decide. This does not mean he's going to trial yet. This is the first hurdle. Because if the government's expert came back and said he is not competent to stand trial, this would be the end of the discussion. Like, do not pass go, do not collect $200 or, tens of millions that you stole from clients. Don't do that. But because the government expert said he's competent, we're going to need to then look at what the defense expert says, and then it will go to court, and then the court will decide. So this is the first hurdle of a race. The government and its experts should have the ability to refer to the entirety of the evaluation, including any statements purportedly implicating the defendant's Fifth Amendment right. Part of competency is going to be like, he knows what he did, and he knows that it's wrong. This goes to competence. This goes to competency. Accordingly, and in light of the upcoming competency briefing deadlines, the government requests that it be granted immediate access. I can't wait to read those filings. The way we're going to be covering these filings. Argument: the court's order for mental competency evaluation provided defense counsel the opportunity to review the report of the government's expert prior to release to the government, to make any redactions necessary to protect disclosure of privileged information. That's going to be attorney-client privileged information, not Fifth Amendment information. The order also gave the government the right to request in-camera review to the extent there were disputes on the redaction. So the court's going to read the whole thing unredacted and decide what redactions should be there, right? To protect the rights of the defendant. Defense counsel provided the government with the redacted version on June 5th, wherein significant redactions had been applied to nearly 10 pages. The government filed the redacted report under seal and noted that the government had not yet had the opportunity to review the significant redactions. On June 7th, the parties met and conferred via telephone regarding the redactions of the report. Counsel for defendant stated that the redactions were based solely on defendant's assertion of his Fifth Amendment right and not any other assertion of privilege. And that's wherein the problem lies. This is not attorney-client privileged information. This is incrimination issue. This is incrimination information, and that comes in for a competency hearing, not at trial. The government agrees the statements made by defendant during the competency evaluations are not admissible against defendant at trial unless he raises a mental status defense. However, invocation of the Fifth Amendment is not an appropriate justification for redacting the statements. So this is simply asking the court to rule that they should have access to the redacted portions of this report to be used for the limited purpose of the competency hearing. Those filings should be coming in shortly. We should see those filings coming up at the end of this month, beginning of next month. And then we can start to go through the arguments regarding Tom Girardi's competency to stand trial. So with all of that, is Tom Girardi going to trial? Maybe. Could the court find him competent? Maybe. Could his mental status or competency status change throughout the course of trial? Yes. Could that mean he never goes to trial down the future? It's possible. And this is the thing. Humans are dynamic. It's a dynamic situation. But at this point, the reports say that he's competent to stand trial, and that is a very difficult threshold to overcome. When you see somebody found not competent to stand trial, that is a very big threshold to overcome, and it means they truly cannot be held accountable in that way. And we can go through what that means later. So, are we ready to go to the Kohberger hearing? Because we have an hour and 36 minutes of this hearing. Let me make sure the volume is golden. I'm going to turn this up a little bit on my end. Just a reminder on the court volume. Here's what I suspect, just based on being a person that does video. It seems that the audio that the court TV cameras have grabbed are on camera audio, and that it is gained up, and that is why there is a ton of noise, like white noise in the background, a ton of background noise, because court TV cameras are not yet plugged into the microphones in the courtroom. So with that, Are you ready for this hearing? Let's do a quick, what are we talking about here anyway? This is the entire hearing of Bryan Kohberger's second hearing with regard to the gag orders and cameras in the courtroom. This is regarding the motion from the coalition of media outlets. And while there are times I am critical of the media, and I will be back and forth, I'm glad that they are pushing back here. And we are seeing a coalition of the AP, Court TV, Law and Crime, and others saying, no, we need access to the courtroom. I don't know if they're going to get a modified court order, but I'm glad they're fighting for cameras in the courtroom. The judge, at the end of the day, takes this under advisement. But the reason I want to watch is A, when the judge's ruling comes down, I want to be able to understand. And B, I want to see what the judge's attitude is, because you can tell. You can tell how the judge feels about something pretty well by the way that they respond to questions. And I think that y'all saw that in the last hearing with the Gonsalves family attorney, Shannon Gray. You could see where the court was pushing back, and you could see what the court wanted to talk about and didn't want to talk about pretty well. So that is what we are talking about today. So let me make this, and big in my screen. Let me make this full screen. Oh, it doesn't even matter if I make it full screen. Here we go. Let's make this full screen. Let's pull me up. I will move me around if need be. There we go. And we'll go from there. So I will keep an eye on that, but I'm also watching this hearing. Where is my notes? I will find my notes. Let's get this hearing started, and I will find my notes while we do. Hopefully this is not, well, the audio is going to be bad. So we're just going from there. All right. Thank you to the cameras and Court TV for capturing this hearing. Let's go. That's right. That delicious audio we've come to know and love.
Thanks very much. Please be seated.
Delightful.
Good afternoon, everybody.
Notebook. Water.
Okay, let's sit on the record, please.
I need to put a sticker on this notebook so I remember which one's the front.
We are now on the record, State versus Bryan C. Kohberger, CR 29222805. In the courtroom, Mr. Kohberger is in the courtroom.
Hold on. I'm going to try to gain this up real quick. Give me... Let's see. Hopefully this will be a bit better. I can barely hear this judge. All right. Let's see if that's any better.
With his attorneys.
That made zero difference. Hold on. He's calling the calendar for the attorneys.
Sorry, I missed you because you were behind the screen earlier, but also...
All right. That actually seems better.
Ms. Massa is also present. Representing the state is Mr. Thompson and Mr. Rudley, and we're really here for the motion Associated Press et al. I'll call you
the Media Coalition.
Non-Party Media Coalition. So Ms. Olson and Mr. Carone could come up, or I don't know if it's just going to be you. Ms. Olson?
I will be the only one arguing, Your Honor.
Okay, well, thank you. So we have a lot of things to sort of sort through.
Yep.
And I know some of your clients are listening on Zoom, and I can't look at all of you while I'm looking at here, but I just wanted to acknowledge that. So
representatives from the Media Coalition are on Zoom.
The motion to intervene, but let me just tell you my thoughts about that.
He's going to let them intervene on this.
After reading the Supreme Court's decision,
hearing, I think
the coalition has standing, and so I think you're entitled to be here and make the argument. But I don't know that I need to grant intervention. But I don't know, what's your view of that?
Your Honor, we think just to have the clearest record possible, that the court should grant intervention for this limited purpose. We think that would frankly also be helpful should the situation arise again, since there's simply no rule that sets out whether we can do this or not, which is among the reasons we went the wrong place the first time. So we would ask that the court grant the motion. I don't intend to offer any other argument other than was offered in the briefing matter.
Okay, let me go to Mr. Rudley or Mr. Thompson.
Your Honor, we don't have an objection to granting the motion to intervene for the limited purpose of challenging the amended non-dissemination.
Okay.
Ms. Taylor?
For those of you asking, who is this? This is the attorney for the Media Coalition. The reason this angle is what it is because Court TV cameras, here, let me move me real quick. You can see down at the very bottom of the screen, there are some chairs. They look like green leather chairs. That is where the media or the camera is sitting, is in this kind of line of chairs, or right behind this line of chairs from the gallery forward. When Court TV does this for trial, if you see where the clock is, there will normally be a camera in a black shroud back on that back wall, somewhere back here, and that's how you get those multiple angles when they're in trial. But for now, we've got this angle, and that is it. Can I turn on closed caption? No, there is no closed caption on this feed, unfortunately. So you should be able to turn it on your device, hopefully.
We don't have an objection.
Okay, great. Okay, so I'll grant that request for the limited purpose. The reason I was worried about that is I don't want the media to be really, so to speak, a party that has to be involved.
They can intervene
in
without
so
being a
many
party.
things that we're going to be dealing with. So, but I will grant that request for the limited purpose of what we're talking about here.
Thank you, Your Honor. And then there's just one other housekeeping matter. As the court indicated, some of our clients in the coalition are participating by Zoom. They have been informed and directed that they may not record the proceeding that's occurring by Zoom, but they may report on it after the fact, just like any reporter here in the courtroom, or as if they were with us here in person as our party representatives.
Okay, agreed.
Yes.
Thank you, Your Honor.
All right. The next issue, though, is this motion for shortened time. I didn't sign that proposed
That's
order.
frustrating. Sorry, y'all. This hearing does not happen.
And let me hear from you first about what that might mean for what we're going to do today.
Well, Your Honor, I think given that the hearing has been scheduled today, the court has in essence granted the motion to shorten time unless it would be allowed. Don't just slow down. Yeah,
This attorney, I was just in my brain going, this attorney is talking so fast. There's no way that the court reporter is getting this. And you immediately hear the court reporter come in with, excuse me? And the attorney's like, oh, so you want me to slow down? Yes. I can't understand at all what you're saying. I have no idea what that attorney just said, but I do see the bailiff laughing because this attorney was literally sprinting with their words. This happens in court.
I think the court has indicated it's going to grant that motion. We're having the argument on it today. I think the one potential sort of hiccup there or sticking point there might be with respect to the evidence that Mr. Kohberger wants to introduce, to which we do object, given we became aware of it 3 days ago, and there simply hasn't been enough time to vet the information that they seek to provide. And as we set out in our reply brief, we think it's not appropriate anyway, given it's the time for them to have introduced evidence in support of the gag order that's in place was in January of this year. So I think that might be the only sort of hiccup with respect to whether the court might end up shortening time or giving them additional time to present that evidence.
The argument, I'm going to be stopping to translate because it's so hard to hear. The argument is that the Media Coalition has not had time to vet the defendant's witnesses. Remember, during this hearing, we're going to see the defendant's witnesses about the gag order, and I think cameras in the courtroom. So that's where we are at.
Well, I haven't approved the shortened time because I wanted to hear from counsel how they viewed that.
Yeah, this attorney's been hard for me to understand.
I know when I talked to Mr. Crone last time, I was concerned about the short time, and I was really, I don't know, maybe it wasn't very direct, but encouraged that we allowed a little more time, because I know there was going to be a lot of briefing. At that time, I think Mr. Logston, said that it's going to be really difficult for us to get things together for an expert, but we'll do the best we can, is what I remember.
And the expert is on Zoom.
So here we are. I was also concerned about the massive amount of briefing that I had to go through.
It was a lot of briefing, Your Honor, and it all came in at once for us because it all got dropped on the website at once. It was a lot of briefing. It was a lot of briefing.
Very quickly, which I did, and I want to make sure, because this is a very important decision, that everybody has the opportunity to weigh in with what they want to present. So, maybe I should go to Mr. Logston and see.
May I offer one other comment?
Well, yes, go ahead.
Your Honor? So, Your Honor, understanding, I think we all agree that this is an important matter to address, and that there are significant interests at stake among both the parties and then the interveners.
There are
And I think our
significant
concern
interests
wanting
here.
to move it forward sooner rather than later is that this gag order has been in place since January, since virtually the inception of the
Well,
case.
you're the party that's harmed if we don't move forward,
has,
so just move forward then.
It has rendered harm to our clients' interests, and so that's
Okay,
why
then
we
just
want to
go.
move forward
Cool.
quickly. And that's why we had offered, we thought, as sort of a interim step, and we were at the hearing this morning, we heard your comments to Mr. Logston at the end, but that's why we had sort of offered as a interim step, vacating the gag order pending a more fulsome evidentiary hearing.
By the way, I mean, just so you know, I find that to be a very kind of inaccurate and distasteful name for the order.
Oh, shit. Inaccurate and distasteful name for the order. We need to back up a few seconds to hear exactly what she said, because when you get the judge telling the attorney, I find that inaccurate and distasteful, well, it's not going to go well for you as the attorney, because you've already pissed off the judge. But we knew that we knew that previously from the way that the judge addressed the media coalition at the last hearing at the setting date for this. We knew the judge was already kind of put off with what the court felt was the over heavy-handed language that the media coalition was using. So this attorney knew going in that the judge was not feeling it and still charged to double down. I don't think it's gag order. I think it is. I think there was more said there, but this attorney, again, is facing away from the audio on the camera and is a little harder to understand, and maybe is projecting to the court and not mindful of the cameras, and that's fine. But let's see.
We thought, as sort of a interim step, and we were at the hearing this morning, we heard your comments to Mr. Logston at the end, but that's why we had sort of offered as a interim step, vacating the gag order pending a more fulsome evidentiary hearing.
Oh, vacating the gag order pending a more fulsome hearing. So maybe it is the word gag order that he doesn't like, versus non-dissemination order.
By the way, I mean, just so you know, I find that to be a very kind of inaccurate.
Chat, again, you are correct.
Distasteful name for the order.
The non-dissemination order.
Had trouble about that for a long time, and it's not called that. So I would appreciate not using that term. It's distasteful.
Also, if you're in court and it is all of the motions say non-dissemination order. So every single motion you file say, motion to vacate non-dissemination order, sticking to the formalized languaging in court is clearly something that matters to this judge. And courts vary in their formalities. Judges vary in their formalities. Some courts are more casual. Some courts are more formal. Some courts are more casual in their dress versus their languaging. It just really depends on the judge, which is why you need to be able to read the judge that you are in front of. This judge is not thrilled. He's like, call it the non-dissemination order. And you don't want the judge to be on you about your languaging. Start with being more formal and work backwards from there as an attorney. You know, you have to move back from formality. You start the most formal, unless your judge is not a super formal judge and you get to know that courtroom. So this is the judge letting this attorney know again, hey, that's not the name of it. So is it the judge not being picky? The judge is being precise. And in this jurisdiction, it's called a non-dissemination order. That's what it is called. The other is kind of a nickname for it, a gag order. And he's like, that's not what it's called. It's a non-dissemination order. And so that's part of what this is. And at the end of the day, you have to play to the judge that you're in front of. So if there are judges that, there are still judges that believe women should wear skirts, you have to know if you're choosing to not wear a skirt in court that you're making a conscious decision. Because your job as an attorney is to best represent your client. So your job is to not piss off the judge by merely breathing or existing. And that can feel very frustrating to attorneys. However, there are some judges that hate bow ties, and you can tell that they hate bow ties. And they want people to be in a shirt and a tie. It just depends on the judge. But part of lawyering is being able to morph yourself so that the person you are in front of can hear your argument. And that's the same for juries. Depending on your jurisdiction, you have to kind of morph yourself into a package to meet your jury's expectation of you as the attorney, so they can just listen to the words coming out of your mouth instead of being like, is that a nose ring? Does she have a nose ring? Why does she have a nose ring? She's the prosecutor. What's going on? Those are a lot of earrings. Do you think they're real diamonds? I don't know if they're real diamonds. You have to put yourself to the back so that the jurors aren't focused on you. As the attorney, you are very, very rarely the star of the show. Cross-examination is kind of one of those moments where you're the star of the show, but you have to play the role. It's part of court, and it is part of doing it. So it depends. Some judges, as long as you're in a suit, they don't care. Some judges don't expect women to wear suits, but expect men to wear suits. The way that this played out in Los Angeles, women could generally get away with a blouse and a skirt, or a blouse and slacks. And the men were like, I have to wear a jacket all the time. It's like, complain to me more about how you're judged if you're not wearing a jacket. I would sure love to hear how hard this is for you. No, not all the judges require women to wear suit jackets. Some of them were fine with a blouse. It just depends on the judge. And you need to know the judge. I found that LA courtrooms, dress-wise, were kind of in the middle. Other courtrooms I've been in are more casual. Other courtrooms I've been in are way more formal. Anyway, that's enough about lawyering. But yes, you gotta dress the part, because you have to meet expectations, and that can be exhausting.
And I think it's inaccurate, and I think it's been
He's mad.
overstated, just the impact of that order, just to let you know.
Thank you, Your Honor.
Okay. Well, and so you are, why don't I go to Mr. Lofton, and we'll see how we feel about the presentation of the evidence and or expert testimony. Go ahead.
Your Honor, we have two witnesses. We also filed, as I'm sure the court is aware, a motion.
Two witnesses for the defendant.
Take judicial notice of the media coverage in this case. The media, as we understand it, is essentially objecting to there being a record made at this point. Our stance is this is a live issue, and this will not stop being a live issue so long as our client is in this case. And as the facts, reading it from the United States Supreme Court case would come down a year from now, it would change us too. But as things change, everyone has the right to come into this courtroom and say, we'd like to have the non-dissemination order reconsidered, amended in ways that are going to match with what's actually happening. The media has made the point that when this originally was put in place, it was just the parties agreeing that we wanted to make sure that we were doing everything in court and not doing it to the press. And so we didn't, at the time, feel the need to make a big record about what was going on. I think the court mentioned that to some extent what's going on is so obvious. And while we would concur with that, given
I would like to see the attorney as well. There we go. I'm fine with that shot, but I want to see the attorney and the judge. Kohberger's face tells me nothing about what's going on in this case.
Amount of coverage, of the consistency of the coverage, and to some extent of the substance of that coverage. And that's what Ms. Saucier would be talking about.
You can't control the substance of the media
and then
coverage.
We also brought in a psychologist.
I went through this maybe on Friday through the motion to take judicial notice of the media coverage. The court does, like, these are the headlines that exist. This is what's being talked about and what's happening, but they can't control how the media talks about this case at all.
Professor of psychology from Eastern Washington University, to basically just kind of talk about why we care. I mean,
we know why you care.
That we talked about in the brief that aren't related even to the biases and things like that. Or we just have overall concerns about, as a country, how do we resolve these cases? Is it in the press or is it in a court? And those are issues that we don't necessarily need these witnesses to get to. But to the extent that the United States Supreme Court has clearly shown that we do concern ourselves with the effect on jurors, and even the effect on ourselves and our witnesses, that we brought in a social psychologist.
I just have to say, there is someone sitting next to this camera with a laptop, and it sounds, all I can hear right now is the laptop, and so I am trying, but the camera operator, it being right next to people, this is part of why I think the microphone is on camera, or at least next to the camera, because it's picking up the sounds back by the camera more than it's picking up what's happening forward in the courtroom, and it's hard.
Explain what those issues are a little bit better than we just sort of understand. But in terms of, our position is the court needs these things. We think that they're best to make the record in the case. And I think the court is correct. We thought it would be better having time so that everybody could take their best shot. I feel like we did a pretty good job of warning everyone that we
He's not giving up his shot.
Yeah,
he's not throwing away his shot.
Time, like I said, it's a live issue. The court could issue something today, the media could go back, find themselves an expert that they think blows our whole case out of the water, and then come right back to court and say, well, let's...
They're still arguing about whether or not to shorten time.
So, I certainly don't have an issue with the media decides what they'd like to do is have additional time to find their own witnesses, for that matter, to prepare more. We're not going to object to any requests to move this here.
Yes, the typing is not me.
Mr.
I wouldn't do that to y'all.
You
Your Honor,
address that. Maybe you want to come up for the mic. Thank you.
I'll be brief, but
I can hear him just fine.
Position on the motion to shorten time or hear additional evidence.
Thank you.
Yeah, I can hear him clear as day.
I'll tell you where I am on this.
This is regarding shortening time.
I agree with Mr. Logsdon that this is a moving process, and analyzing this going back to whenever it was imposed is not particularly relevant at this point. A lot of other things have happened. If there was no order in place right now, I could impose it today based upon the evidence that was presented. But there's not really any evidence presented yet, and that's why I asked for potential evidence to support the record. I mean, I think we can probably agree that this is a high profile case. It's very,
Yeah, we can
there's a lot of
agree.
interest. There's a lot of misinformation and disinformation out there in the public.
Sir, how do we know if there is misinformation or disinformation in the public about this case when we don't know what the information is about this case because there is a non-dissemination order and no one can clear it up? If there was a misperception about why Bryan Kohberger stood silent and there was not a non-dissemination order in place, his attorneys could just release a statement saying, in Idaho, the defendant has a right under statute to remain silent, and the defendant is not accepting the veracity or the truth of the indictment. Period. And they could just clear it up right there. And then it would be clear. It wouldn't be talking heads on Court TV. Hi, sometimes I'm a talking head on Court TV saying, well, it could be lunch meat, could be peaches, it could be this, it could be that. I mean, he could have done this, he might be thinking this. But they can't clear it up because of the non-dissemination order. So that's a problem. Emily, Court TV's cameras were in court. They were the only cameras in court, and they are the only ones that have shared this hearing from Friday. This came out late, because this Friday hearing went very late in the day. We're going to take a second to congratulate writers and readers and then go back to the hearing. Congratulations on your acceptance into your nursing program. It's fantastic. And there is lots of room to overlap nursing into law and criminology. There is a lot of overlap. There can be a lot of overlap depending on what you do in the two. So congratulations. Let's keep going.
And that's quite concerning. My job is to protect the First Amendment as well as the Sixth Amendment.
Fair.
There's a balancing in that. I don't think there's any question about any of that.
It's going to get stuck in my head.
So I'm inclined to allow, the testimony and the evidence. I'm inclined to take judicial notice of the submission of
Fine.
Mr. Kohberger, but I am happy to put this out to give.
The court is taking judicial notice of those media articles that we covered on Friday. These articles exist with these headlines. People are talking about the case.
An opportunity to
All right.
respond to that, because I know it's incredibly short notice.
Thank you, Your Honor. It's 3 days notice, but we addressed some of that. We prefer to go forward today, and as Mr. Longston just acknowledged, if we feel like there's evidence that we find later, we'll probably just file a motion to reconsider it. And I would just like to address one point here. We understand that things evolve, and we're at a different point today on June 9th of 2023 from where the two parties were on the first, I think, January the 3rd, and then with the court in chambers, with no court reporter taking down anything that happened, where you had to file a redacted memo, and then the amended non-dissemination order that came out of that. We understand we're in a different place, but our point is that the court entered that.
This attorney just threw a whole bunch of shade at that initial hearing where the non-dissemination order was amended. That's what's happening there.
Without any findings of fact that warranted such a non-dissemination order that was what we assert is the order in place now was overbroad and was procedurally deficient. And that's really our concern, is that there is a First Amendment harm that occurs from a non-dissemination order that is overbroad and where there was simply no opportunity for anyone.
They didn't have a chance to be heard.
The parties to weigh in behind closed doors with the court. And I was here this morning, and so I heard Mr. Gray say that he disagreed with the record that's been made on that. But I think that's a significant concern, and that the court should be concerned about the procedure that was used initially to enter that non-dissemination order. And that's why we continue to take the position that if the court feels a more fulsome record is needed, that the order in place is simply not justified by what the court did back in January, and it should be vacated pending the development of that more fulsome record, Your Honor.
Whether that's accurate or not, I mean, that's why I'm inclined to allow any of the parties and the media to add to the record. I just want to remind everybody.
They're now talking about whether or not they should continue to have the hearing. So, you know, the judge is trying to keep them from retreading old ground, saying, well, we didn't get heard. Well, you didn't. You didn't get heard then. I'm letting you be heard now. You did. So can we stop retreading about this Zoom call that's happened before it got to this judge? And he's done. So he's trying to move on. And that's what he's really saying is, fine. Yes, things happened. We're here now. Can we move forward?
This initial order was an agreement. It's a stipulation.
It was.
It wasn't that Judge Marshall just pulled it out of, air. It was an agreement between the parties. There are only two
He
parties.
paused for a second there.
To protect the Sixth Amendment. That was the reason for that, and I would note, because I think this is missed in the discussion.
The attorney in the striped jacket is for the media coalition.
That this was going heavy well before Mr. Kohberger's arrest. So there was a lot of speculation, a lot of criticism, a lot of
interest,
bad information, and that would trigger for any lawyer for either side to try to protect the integrity of the investigation and the future court process. So just try to, I do think that this thing has kind of grown a bit out of proportion from where it started.
I think he's talking about
because,
hearing growing out of proportion.
Obviously, if you look at a newspaper or the TV or YouTube or TikTok.
Hi, we're on YouTube.
I don't look at any of it, but the media has freely talked about this case. So
he makes
I think
a good
that's
point.
really kind of the issue. Like, do we have a responsibility to talk to the lawyers about releasing information that shouldn't be released to the public, and allow the media to follow the rule of or the First Amendment?
This is the point he's making. It's y'all are saying, y'all media coalition are saying that the non-dissemination order is so restrictive you can't cover the case. And he's like, y'all keep talking. Y'all keep talking all the time. So what's the problem really? Because y'all are talking a whole lot all the time. And you know what? I don't disagree. Did I hear EDB say lawyer in a straitjacket? No, striped. The lawyer in the striped jacket. Stripes. There is a Navy stripe. Striped.
Freely, which they have. What I hope is that they do it responsibly and professionally and accurately.
Ethically.
That's really up to the media. I can only control so much, and you can control only so much of your clients and other media and media that are not traditional.
Oh no, all of you heard straitjacket.
That is really the
Stripes.
struggle, and that's why the order was entered originally.
And he's reminding them it was stipulated to. It was a stipulated to order.
Understand, Your Honor.
And the media's like, we don't agree.
I can have it once in a while.
Everyone else agrees, but the media's like, we don't agree. And the prosecution and defense are like, we all agree. We want the non-dissemination order. It's the media that has a problem. And the prosecution is now pouring the media attorney a glass of water, which is very kind. This is a courtroom that has seemed to work quite well together.
Why the parties did what they did in the interest of the parties in this. Interveners well understand. Frankly, for Mr. Thompson, and I've been in Mr. Thompson's position in a capital case.
I know, Well, I know you have, and I know you understand the issues here, and that can collide.
Right, what we know is that the state wants to ensure that its investigation, or that in the case that its investigators and its prosecutors put together and presented to a grand jury and obtained an indictment, that they can present that case the strongest way possible without having to worry about external events, and certainly external events they can't control. And we know that Mr. Kohberger and his counsel have a tremendous interest here in fighting for his freedom and likely fighting for his life. I heard the court earlier today, and I think all of us who have practiced in this area at all know this is likely a death penalty case, but that, those are not decisions that have been officially made yet, and that hasn't been put before the court, but that's why Ms. Massoff has been appointed to help represent Mr. Kohberger. She's an excellent attorney. I know her well.
And death penalty qualified.
And I know that they have an interest in making sure that when it comes time to
What you just caught is that these attorneys know each other, and that this attorney for the Media Coalition used to be a prosecutor, and she is talking about Bryan Kohberger's attorneys. At the beginning, when they walked in, you saw Bryan Kohberger's attorney wave at the media attorney. That's not uncommon, especially in small jurisdictions where you will get attorneys that know each other, and you will get prosecutors that go and work in private interest after they are done prosecuting, because being a prosecutor or a defense attorney, well, being involved in the criminal justice system at all is a tremendously difficult job. And so I'm not surprised that these attorneys all know each other, but now it's kind of confirmed. You saw the wave earlier and you're like, do they know each other? Is that who they're waving at? But now you know that this attorney has practiced in this area, and you want local attorneys to be in court because they know the participants. So that's really helpful to know. That's an interesting little tidbit. Let's keep going.
the jury, if this is a case that ends up going to trial, that they can pick jurors who will fairly and impartially hear the evidence and make a decision based on the things that they hear from the witness stand, and not based on what they see on Twitter or the internet when we're watching the news. And that is a fundamental interest of this entire system, which frankly I spent most of my career working in.
Well put. Thank you.
But there are also, this court has tools in addition to non-dissemination orders to make sure that there is the best chance to get a fair and impartial jury when this case is heard, aside from a non-dissemination order, which I'll come back to the parts where I find to be overbroad and not having been procedurally
Yes, we know.
accurate.
Stop retreading.
There are jury questionnaires. There's change of venue. There will be the passage of time, and I think that's where
There's one here.
this is a potential death penalty case, that comes into play. If the state files a notice of death penalty, and it becomes a death penalty case, I would be stunned if this case went to trial on October the 2nd of 2023, because the defense will need to do a mitigation investigation. The defense will need to look at experts from a host of areas.
Okay,
Will
but
be able to present evidence about Mr. Kohberger.
can we get back
his
to,
life,
should this hearing
and
happen
why
today?
the aggravating factors that would perhaps the state
Yes.
would consider, why those should apply and why the jury should choose a sentence.
The point has been made. There are options.
After a guilt phase. That takes a substantial period of time, years in many cases. And the passage of time, I understand, we've looked at all of the materials, not in great detail, the materials that Mr. Logsdon submitted from Ms. Saucier and the professor from Eastern Washington. And we understand that there was a lot of publicity now, but I will tell you one of the things that was most surprising in the Duncan case, and I gotta say also,
Tell me what's surprising.
You're just living that case, you think that's all anybody thinks about. But the most surprising thing to me when we picked the jury in the Duncan case, 3 years after the murders, was that there were people who hadn't even heard about it.
Right.
Heard about it. I mean, and that's a case where, granted, the trial there happened in Boise. That's a case where, again, we didn't have social media to the same extent yet. But there were cars in Coeur d'Alene driving around with "Kill Duncan" bumper stickers, and there was a donut shop that had on its magnetic reader board "Kill Duncan." That's pretty prejudicial pre-trial publicity, and those things would get picked up in the media. So that
What she's arguing is she's shifted back from should we have this hearing to why do we need to have this hearing to why the non-dissemination order is overbroad, and saying that the court has other remedies. The court can voir dire the jurors. If the worry is protecting a jury pool and finding an untainted jury pool down the road, if that's really the court's concern, her argument is you have other options to pick a jury. You can move venue, you can wait, you can voir dire extensively on this. And she's talking about a highly publicized case that then had people who had never heard of it years later. And we know that from other cases we've covered. We know that they found jurors in Depp v. Heard that are like, I think that's the guy from Pirates. I don't know who she is. I didn't know there was a case going on. IDK. Like, we know that in Brooks, they were able to find impartial jurors, though in the Brooks case, that impacted the entire community and it was widely publicized and a lot of the community was there. So she's saying, look, there are options. Those options don't have to be this overbroad, as she is arguing, court order or non-dissemination order. And that's fair. There are other options. And there are always going to be people that don't give a shit about any of this. There will always be people that are like, miss me with what's going on in court and these cases and blah, blah, blah. I don't care. Just like there are people who don't give any of the shits about Vanderpump Rules. It was talked about at the White House Correspondents' Dinner. But if half of you had, more than half of you, let's be fair, if half of you had to sit on a jury to determine who's in the wrong between Tom and Ariana, most of you haven't even watched the show. You're like, I could be an impartial jury. Who are these people? I don't care. They found a jury for the Kardashian case, and all of the Kardashians and Blac Chyna were in that case. And they found jurors who are like, miss me with these people. I know nothing about this. You can find jurors.
The passage of time with the probing voir dire, the questionnaire, and the change of venue.
So that's what she's talking about, the other options. Other
A
options.
fair and impartial jury that was in panel. And so those tools, we would submit, are available to this court. Because in addition to the very important interests that Mr. Kohberger has, and the very important interests that the state has, and I think as Mr. Redley acknowledged this morning, the state also has an interest in ensuring there's a fair trial. The media does have an interest in enforcing or fulfilling the dictates of the First Amendment and the free press. And those are equally important principles, at least at the stage of beginning to weigh them, Your Honor. It's through the members of the media and the press that the public learns about these proceedings, that the public is able to understand how the criminal justice system functions, that the public is able to understand how the prosecutors perform, how the defense attorneys perform. That's how they learn about details of the investigation when they're released, either in the courtroom or released through the probable cause affidavit, so they can make their independent judgments about how is our system working, so they can be educated. Just as the court did this morning when it started the hearing this morning by pointing out or explaining why someone would come into court and not enter a plea when called upon to do so, then the court has to enter a plea for them. And those of us who have been in the criminal justice system have seen that before. So it's that kind of educating that can be done by the court, by the people who actually know about proceedings. I see no reason why after that proceeding, Mr. Thompson might not have been able to, or Mr. Lawson and Ms. Taylor, been able to answer a question about, wow, well, that's unusual. Can you really do that? And someone say, well, you know, actually, under the rules of criminal procedure in Idaho or under case law in Idaho, you actually can just not stand silent and not enter a plea, and then the court has to enter not guilty pleas for you. That would have been a very helpful thing to have done.
She's making the argument that because of the non-dissemination order, Bryan Kohberger's attorneys could not clarify why he stood silent. That I made that argument earlier. Also, my kiddo says hello. He was trying to determine if we had baking soda and baking powder because he is determined that cookies are on the agenda for today. I'm very excited about that.
I think it is educational things like that that can be relayed through the media, that the current non-dissemination order restricts these attorneys we're speaking about, or really any attorney, because it's the way it's phrased, any attorney with the interest.
I'm an attorney. I'm interested. I am not prohibited from speaking on this case. Hi.
For a party with interest in the proceeding. That's pretty broad. That's extremely broad. It's not just Mr. Thompson. It's not just Mr. Logsdon, Ms. Taylor, and Ms. Matzoff. And what does that mean to be a party in interest in the proceeding? We talked about the motion to intervene, but we wanted to make sure it was a limited purpose so that we suddenly don't become a party with an interest in the proceeding. And then I can't walk outside and talk about what went on in court.
And they talked about that earlier.
What we're asking for is the court also to look at what is the First Amendment, what role does it play in the court's analysis? And how can it balance those First Amendment rights and use those other tools that are available to, particularly at this stage of the proceeding, to ensure that the Sixth Amendment right is observed and that the First Amendment right is observed. And we think, Your Honor, in doing that, you have to take a look at the non-dissemination order and apply strict scrutiny analysis. And there's lots in the briefing about strict scrutiny analysis.
She's arguing that that should be the standard, is strict scrutiny.
One, because we view this as a prior restraint. In order to have news or publication, you have to have not only print the information, but you have to be able to receive it. And if you can't receive it, you can't present it to the public.
Is there law on that?
There is, Your Honor. There is, Your Honor. It's in our briefing. And I was asking
Which
people to take
case?
a look at pages 15 and 19.
Oh, thank you.
It's not in one of the big three Supreme Court cases we've all talked about. It comes primarily from the Young case, but that's where that comes from. There's nothing in those three Supreme Court cases that says that you don't apply strict scrutiny when it's a restraint on something other than the media, other than perhaps the Gentile case where it says they're talking about the lawyers and it says
They're talking about the standard the court should apply to determine his ruling.
Publicity. And then you have to have a narrowly tailored tool that's designed to restrict it. And Your Honor, regardless of what the test is, there has to be prejudicial pretrial publicity. Publicity that could prejudice Mr. Kohberger's.
I don't know. Do y'all think some of the pretrial publicity has been prejudicial to Mr. Kohberger? That's what they're trying to argue. Would this pretrial publicity be prejudicial? Some of the coverage is like, look, these IDs that were found, they could be the victims. Nobody knows that. Nobody, and they haven't been able to correct the record on it either because of the non-dissemination order. I don't know. You guys let me know what you think about the coverage that you've seen.
Right to a fair trial. So publicity generally, and I think this is where Mr. Logsdon submits in Saucier's information, there's no reason to think that publicity generally is prejudicial. It's a publicity about the case, and it allows people to hear about the case. But some of the things people are hearing about the case may not be all that flattering for the state. It may be not prejudicial to Mr. Kohberger. It may suggest things about the investigation and how it was done.
It doesn't matter which party it's prejudiced to.
In and of itself is not prejudicial. And that's why I think when you get to what is out there, that courts typically rely on first blush is Idaho Rule of Professional Conduct 3.6. And those line items of what attorneys for parties in the litigation may not comment on. Those are rules that are vetted, and they're the same as the ABA rules.
And those are right. Those are in the model rules as well. Those are in the legal rules for lawyers.
Prosecutors, you don't get to walk out of the courtroom and say, well, in this case, we've got the guy because X, Y, Z, whatever. And if you're, you just can't do that under the rules of professional conduct. And there's no reason to think.
She's arguing that there are already rules in place to deal with pretrial publicity under the rules of professional conduct. Therefore, we don't need this expanded non-dissemination order.
Any of these lawyers who all are fine officers of the court are going to ignore their obligations under Rule 3.6. I understand their desire and their interest in having something more prophylactic so that they can operate in a way that doesn't, so they frankly just don't have to worry about that. But it's our position that the First Amendment requires more and much more, and requires a narrow tailoring. And that when you have a non-dissemination order that starts out and says all extrajudicial statements, it cannot be made. And
I can fix that, can't I?
Sure.
I mean, so if I just, and I kind of raised this morning too, that if I am more specific about who is touched.
Correct,
by this
and that's probably
order
what he's
and
going to do.
What can people say and what can't they say, then that would help your concerns, wouldn't it?
It would, Your Honor.
And I'm acknowledging this because your motion is to completely vacate it.
Absolutely, Your Honor. And the reason it's to completely vacate it is because we don't feel it's narrowly tailored. And so a overbroad, non-narrowly tailored order that, and I respect what the court said about procedurally how it came into place. That might be one where we just have to agree to disagree. But it's our position that such an order should not be in place. If the court then wants to
that's
enter
not gonna
another order,
happen.
then it has to do something that is designed to address or limit
The parties
substantial,
stipulate
you know,
that's not gonna happen.
substantially prejudicial pretrial publicity and make sure that it's narrowly tailored. And that's why I think, Rule 3.6 continues to sort of be the guiding star on that, because it lists the things that tend to be most prejudicial. And so certainly, if the court takes a different approach, we will look at that, and we would certainly hope that the current order we think is overbroad and procedurally deficient, and we recognize the court's ability, to hear all that it's going to hear, and if it chooses to craft something and still thinks one is appropriate, obviously we'll take a look at that and see whether we think it still suffers from the same deficiencies as the current amended non-discrimination order. I would also say, Your Honor, because I heard your questions to Mr. Bryan.
Yeah, I'm glad you're here. I'm glad you're here, so yeah, you might want to address.
And so this would be our position with the concept generally, setting aside, our position that it shouldn't be there at all. But I think that limited to Rule 3.6 is palatable, at least because that's the obligation that the lawyers on both sides already have. I think it would be very difficult to then have a list of things that you could say. You could say this, but you can't say this, because then it would be impossible to think of every possible statement that could be made.
That's a fair point.
There's direction on the statements that cannot be made, and they are the things that are set out expressly in Rule 3.6. That gives very clear direction, is consistent with the Idaho Rules of Professional Conduct, and would leave sort of no guessing for the people who do want to provide adequate guidance and information. And then we would also ask the court not to do something about the language that says attorneys for all interested parties. I think, frankly, that's sort of just inherently vague as to what that means.
As to what an
And
interested
when there are
party
very
is?
specific parties here
All right.
before the court, I think the
I don't know if
court
that's
really
well.
could narrow that.
Mr. Gray
And
seems to
I
think
the
it's
dialogue this
vague.
morning with Mr. Gray regarding witnesses, and I will say, Your Honor, that's obviously not, I think our preference would be witnesses not be included, but when one looks at, for example, the family member witnesses, and the fact that they may be called, certainly if there is a sentencing phase of this, and they may be called by the prosecution to show victim impact, to provide that information. There's very detailed law on what you can have a family member say in a capital sentencing hearing, and it's usually the kind of thing that is, my child was a great kid, they brought, the light of everybody's life. Here's the video of them dancing at their, 5th grade Christmas program, and that sort of thing. It's not details about the case. So for those reasons, we would think something that restricts witnesses who are not going to be fact witnesses in the guilt phase, we think that would certainly be overbroad as well.
Okay, so let's go back to, because we kind of,
No!
that was great.
Don't
Thank
go
you.
back!
I appreciate everything that you said.
Oh.
That,
Why are we going back?
I am going to grant the request
Okay.
to present the evidence or, I don't know.
Take judicial notice.
Submissions, we'll just say. And take judicial notice of that and allow for the testimony. But you will have an opportunity to come back if you choose to do that.
Well,
Oh,
I'll probably do some
no.
cross-examination today. Probably won't be as tight as it would be if I had an opportunity.
Absolutely, you have the opportunity to do that.
And I think, Your Honor, just to be clear, we made some arguments in our reply brief about why these individuals are not the experts. They would never qualify as experts under the federal rules of criminal or civil procedure. based on the things that they list in their
You haven't
CVs
argued that
and their
yet.
prior work. I mean, if they're only offering this Saucier to say there's lots
We're
of things here
arguing
about
now,
this case, I don't think anyone's going to disagree with this. But I would point the court to now, and then I don't know if Mr. Lawson asked her about this on direct, but in her report, and she's got some little tables, and it's not, the version we have is not tabulated, but there are two tables, and one says authority figures share a voice, and then non-authority figures share a voice. And on authority figures share a voice, one of the people that's listed on there is David Nye. And I don't know why David Nye is someone that they're saying is an authority figure on all of this. David Nye is a federal district court judge in Idaho, as the court was. Maybe they meant Jeff Nye, who I think is assisting Mr. Thompson, but that's, I anticipate is an error in the report. And then if you look at the next page, non-authority figures share a voice.
This attorney is looking at a report provided by a witness that is going to testify. We don't have enough for the class. Those have not been provided through the court website, so we don't know what she's referencing. So there is nothing more difficult than saying the chart says this and this and this quickly when we all don't have the chart and we're just like, okay. So right now she is talking about whether or not these witnesses will come in and testify and whether the witnesses for defendant Bryan Kohberger are in fact experts or not. That's what's being argued. We've shifted arguments into whether or not witnesses are happening.
And then share of voice media coverage. The person with the greatest stories in the data set is Rebecca Boone, who's an AP reporter. And then the same thing with shared voice media coverage. And of course the AP stories run all over the country and they get shared in different publications. So I suspect that might be one of the things Ms. Saucier will say about that. But the definition she uses in her key terms defined is authority figures are experts who are currently working on a case.
Oh my God, I can't follow along.
Authority, that's too much caffeine this morning. Authority figures are experts who are currently working on the case. Well, David Nye is not currently working on the case.
Who counts as currently working on the case?
Per definition, experts who currently work in or formerly worked in the field of law enforcement, police or FBI law, such as lawyers or other court-related personnel, but who are not working on this case. Rebecca Boone isn't any of those things, and she's the primary person they put forward in that area. So if the court wants to consider that, I mean, I think just right off the bat, there are a number of things that make it inherently unreliable.
Let me just be candid. I mean, I'm not going to put a lot of weight on that because, as you said, starting out is, I mean, there's no question about how much information has been poured out about this case. I'm allowing Mr. Kohberger to make a record, okay, because that's something that
He's allowed to do.
That has been raised by you and your clients, that there's not a record to support this, to justify it. So
they get to make a record. You raised the issue. Fair, Your Honor.
Weigh in with what they think justifies an order. And I don't disagree with what you're saying about narrowing or being more specific. One of the questions I heard you talk about prophylactic, and I think that's an interesting question when you talk about other options to deal with.
There are a lot of other
trial.
options, though.
Going to another venue, for example, or sequencing. Yes, thank you. That is complicated. It's expensive.
Yeah, that's true.
Time-consuming, and so if we can be prophylactic about it by limiting, okay, what lawyers who have a different standard, okay, lawyers who are actually directly involved in the case have more credence, okay, in the public, and that's a reason to restrict that. And that's why I don't like the term gag order, because nobody's really gagging about it. Okay, these are lawyers.
The media's gagging about it.
Restrained by
They
ethics
feel restrained
and professionalism. So that's really what we're talking about, to kind of do what we can, even though I don't even think the media can really control all the information that's going out there.
Oh, prophylactic is used in law a lot. Prophylactic, I mean, might also be a medical term, but it's used in law quite a lot. It's used in law quite a lot because it is exactly what it is. How can we deal with this before? So it is used in law quite a bit by courts.
Every minute, right at this moment.
I-
And so this is not the same world as it was 10 years ago.
It's not the
or
same world that it
5
was
years
5
ago.
years ago. Yeah.
And it is troubling for the media, the ethical, hardworking media, and the information that's swirling around in the world. I don't know what the answer is, but it's a serious threat to a fair trial and the credibility of the media. It's just a side speech.
He just sidebarred on himself saying, yeah, the world is different and that's a threat to the media, but that's not, the judge is like, but seriously, bro, not my problem. My problem, the court's problem is, my problem is defend the rights of this defendant and make sure that this courtroom is protected and that the Sixth Amendment rights of the defendant are protected and that the pretrial publicity doesn't create a situation where this defendant cannot get a free trial. The judge is worried about what happens in the four corners of his courtroom when a jury has to come into that courtroom, not whether or not the media would like to be able to get access to a 911 call or not. That's not his problem. And so I think we see how the judge feels about the non-dissemination order, which is he's not getting rid of the non-dissemination order at all. He might modify it, but it's not going anywhere.
I apologize.
And I'm not sure that anyone would disagree with that. I mean, we live in an age where finding out what the facts are is more and more difficult with every day, and both.
Attorney for Media Coalition. Some in the media are part of the problem.
The participants in this criminal justice system, the court, lawyers for any party, and the members of the media, we all participate in systems that are designed to be fact-based and that are designed, when they function well, to get the information out that's truthful and accurate and through a process that is most appropriate. And I don't think anyone would disagree with you, Your Honor, that right now that there are
Agreed.
because everyone can have a blog or be on Twitter or be on any. There are so many social media channels out there now that a person my age does not hardly know any of them. But those are all certainly out there. And no order from this court, respectfully, Your Honor, is going to reduce any of
True.
that.
She's
But
not wrong.
But when there's an order from this court,
Your Honor, no order from this court can stop the internet from interneting. Because basically, she's saying basically anyone can have an account and anyone, hi, I'm anyone, can pick up a microphone and talk about this case. And the court's order can't stop all of that.
limits the ability for people who have actual facts and good information to provide statements about things like the court did this morning that can educate people about the process. Certainly, no one's expecting that Mr. Thompson or Ms. Taylor or Mr. Logsdon or Ms. Massoff are going to, if the court lists the non-dissemination order, are going to run out and tell you everything they know about this case. They're not. And so
They're
think,
still
Your Honor,
governed by the
when
rules of
okay,
professional
the court-
conduct.
It sounds to me like the court is inclined to have some sort of Second Amendment non-dissemination order. I would urge you to make it as narrow as possible so that the actual facts can be relayed to the members of the media. And I think when you look at who the media coalition is that came before this court, I mean, this is a group of Idaho-based, some Washington State-based. It's hard to be in this part of the state of Idaho and not be completely familiar with Washington, and then some national outlets that have continued to have an
That's true.
outstanding reputation. And what they want is
It's a
for
lot
their
of local
reporters
media, that's true.
to be able to obtain accurate information and information that is of the kind that is not, they understand the things that probably the lawyers are not going to tell them, but information that might help the public better understand all of this. Because the other thing that is just so
Oh, well, there is clearly information missing from this case that might help the media or might help the public understand this case better. But we're not going to get that before trial. We're just not. We're just not. But there are big old gaps in what we know about this case for sure. I agreed.
is the background of all of this. These are tragic events that affected this community, the entire state of Idaho, and there's probably
Washington, the university community. Agree.
In Moscow, who was affected by this tragedy. And I think as part of it, and there are people who really have an appetite for accurate information about this case. And what we would ask this court is not to have any sort of non-dissemination order that restricts the public's ability.
Well, that's where cameras come in. The public is looking for accurate information. Good. Put in a camera and let us watch what's being argued, said, and decided. Hopefully focusing on what is being argued, said, and decided. Put the cameras in then. If the public wants accurate information, you don't get more accurate than just watching it happen. I don't know if you need to worry about the non-dissemination order if that's the case.
To understand these proceedings and to get accurate information.
Great.
So thank you. What I would like to see, maybe we all like to see, is the media actually doing more.
Judge, sir, a lot of us have all the feels about the media. I understand. There are some that are great. There are a lot that are not so great. We all have seen the media shift from factual reporting to opinion to like shaming people to whatever else. We've seen the shift. But now is not the time, Your Honor. Can you please just decide about the non-dissemination order and the cameras in the courtroom? Because if you are concerned that the media is not accurately reporting, and I think that's the direction this judge is going in based on how he started, if that is your concern, Your Honor, the only remedy to that, don't say more cowbell chat. The only remedy to that is to have cameras in the courtroom, because you cannot control someone else's perception or what headlines they want to use for clicks and views. The only thing that you can control, Your Honor, is just letting the public see for themselves and decide for themselves. That is what you can control. Let them see.
Complete analysis of process, okay, and explain to the public why we do what we have to do in protecting a fair trial. I haven't seen any of that. Now, I'm not out there following the news carefully. I think our local press has been really fair and pretty balanced, and I appreciate that they are talking about some of the details and explaining kind of why things are happening.
And your local media is asking for access.
To see more of that instead of the sensationalizing that we.
Sir, do you understand how clicks and views work? Because that is, I know you want to argue about the sensationalized media, but sir, that's how the internet works.
That we are seeing in national,
I mean, not how I work.
The national media. So, and by the way, I haven't made a decision at this point. I mean, when I ask questions like this,
I'm not deciding. I just want to
asking
chat.
My thoughts about where we might.
He's like, let's have a chitty chat.
So, I don't know if you want to address.
We all
anything
miss the
else about,
facts, Your Honor.
About the evidence, or
All of us.
Further your
We miss
argument.
facts.
I interrupted you.
Too much fuckery.
Your Honor, I think we made it all the way through the things that I had hopefully planned to tell the court about the standard it should use to analyze this, the reasons it should vacate the current non-dissemination order, and then our thoughts on if the court is inclined to look at a different measure to ensure a fair trial. that it used some of those tools that are available to it other than a non-dissemination order.
She is arguing her
I think
case,
that
though.
Realistically, the trial in this case is probably at least 2 years out because of all the things that the defense will have to do if this is a capital case. I don't do it well. And you don't do that in I'm bad at math, 4 months.
That remains to be seen.
Did y'all hear what she just said? She just said this case is probably 2 years out from going to trial with everything that's been going on. Stop, ma'am. They haven't waived trial yet. I know that's probably true, but please, 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 no.
I understand.
I understand what you're saying,
Yeah.
too. So, and you're sticking to strict scrutiny.
Yes, Your Honor.
She
I
says
think
that's
two
the
reasons,
standard.
Your Honor. The first is that because we view it as a prior restraint, and because in order to both, it has to be, in order to report information, you have to be able to gather information. And I would direct the court to page 15 of our brief for that. And then separately, Your Honor, when the court is balancing two competing constitutional rights, we would submit that the court has to apply strict scrutiny. I think that's on page 19 of our brief, Your Honor. And then finally, I would say, Mr. Wellington submitted a bunch of materials to the court. If the court's inclination is to sort of give them the weight they deserve, I'm not sure I'll spend a lot more time on it, other than I wanted to point out those 2 quick errors that I was able to find in Ms. Saucier's tables. But we submitted declarations from reporters who I think their experiences illustrate sort of what happens when you have an overbroad non-dissemination order like this, where people who really are not involved in the proceedings, people who are being asked about topics that aren't really directly related to the facts of the case, they're cited in the non-dissemination order for reasons they can't talk to the media. And that just, I think, sort of reinforces why you're going to get the things that we see on social media and the internet, and the things that the court will express concern about.
Well, let's just, one of the problems there is, I think that a lot of the media were suggesting that the order was much broader than it actually was. And so maybe
No. I disagree, Your Honor. The media is suggesting that the order is broader than it is because people are using it as a shield, saying, well, I can't because of the gag order, even though they could because of the gag order. They're using it as a talk to my manager because they don't want to deal with the media. So I can see why the media is saying, nobody will talk to us because of the gag order, because it's real easy for them to say, but Your Honor, there's this non-dissemination order and we don't want to run afoul of the court, and we all live here, so we're not going to talk to you at all. They're just using it as an excuse instead of saying no to the media, hoping it'll make the media go away. Because if you say no to the media, they will try to find your mom's cell phone number and call her and ask her to tell you to have an interview with them. So they're hoping, saying a non-dissemination order, that the media will just go, oh, okay, I guess there's nothing we can do, and leave them alone. This community doesn't seem to be thrilled about the national media attention that is descended upon them. We saw this community putting up signs that said Nancy Grace go away when she set up a card table to get her shot in front of this the house where this crime happened. So we've seen this community be over it. So I'm not surprised that those who are asked for interviews and who are in law enforcement being asked for stuff are saying, no, court order, my bad. So I'm not surprised that they're using it as a shield. I used to do that with my supervisor. It's like, oh yeah, you're going to have to ask my supervisor for that. Bye, don't talk to me.
Responded to that. The other option would be that they were just using it as an excuse because they didn't want to talk to a reporter. And they're right.
Damn it, Emily, keep reading. For just to tell you, I have not watched this hearing. It's over an hour. I have not watched this hearing. I should have just let the judge keep talking, because he said exactly what I was thinking. Keep reading. So the judge said, no, the gag order is not, or the non-dissemination order is not that broad. People are just using it as an excuse because they don't want to deal with y'all.
Well, let's just, one of the problems there is, I think that
Judge loves a chat.
A lot of the media were suggesting that the order was much broader than it actually was.
This judge loves a chat. I like
And
it.
so maybe people responded to that. The other option would be that they were just using it as an excuse because they didn't want to talk to a reporter.
That's the one. Bing, bing.
They're right, right?
Bing, bing.
Absolutely, Your Honor.
That's the one.
That's what they said to the reporters, and that's what those reporters said in their declarations to the court.
So,
That's the one.
Let's just say, just for the sake of discussion, that
Arguendo.
if I just lifted this order, what are you
I agree,
after
Raven.
that the media doesn't already have? You want to be able to
911.
talk to the prosecutor.
Your Honor, they want the 911s. They want the 911 calls. They want the 911 calls. They want body cam footage. They want body cam footage of the search warrants, which they're not going to get, and I don't think should be made public. I think they probably would publish body cam footage of the home. They want more footage. I want to see what they say, but they want interviews with all of the victims' families who probably don't want to give them. They want, I don't know. Let's see. Keep reading.
You want to talk to the defense attorney? I mean, how far does that go? You know that you just can't open their files.
Absolutely. It would just allow them, it would allow Mr. Lawson, if he wanted to respond to a question in the manner that he did in court today about why Mr.
Stood silent.
Kohberger, stood silent instead of entering pleas. It would allow him to respond to that. It might help them describe what's going on in the court. Something happened in court today. And can you explain what
They're
that
allowed
triggered?
to, ma'am, they're allowed to do that under this non-dissemination order. They are allowed to talk about what happened in court and nothing outside of what happened in court. They're allowed to do that.
Things like that. It happens pretty routinely in lots of other
They
criminal
want the
cases.
911.
It might also then take away these law enforcement agencies in other locations who are reluctant to respond to public records requests because they're concerned about running afoul of a non-dissemination order issued in another state. They would simply
Public record requests are used to obtain 911s. One of the biggest questions I think that is still out there is the delay in 911 and what the 911 says. In a lot of cases, you will get the 911 call well before a prosecution. We saw that in Murdaugh and others. They really, really want that. I understand. I also am wrapped with curiosity. However, I don't think that should be disseminated to the public yet. I was really hoping we would get a preliminary hearing and we would have more information. And instead, the prosecution went, no. And they did a grand jury indictment. So we're just not going to know till it gets to trial. It's uncomfortable. We live in a time where I can go on Amazon and get something tomorrow, sometimes tonight. I don't like having to wait either. I get it. But I also don't know if the public needs that information yet. And if the media that would be surrounding something like that then further runs the risk of potentially tainting a jury pool because there's so much local interest, because a 911 call does not always get played at trial. So it's a balance. And I get that it's a balance. I'm curious too. Sometimes the curiosity is not meant to be assuaged because this is a criminal trial wherein 4 people were brutally murdered and we're trying to figure out if the person that the state is putting on trial is the one who did it or not. So our curiosity may just have to fucking chill. I get it. But the media sees opportunity and I get that too.
be better sources of information available to reporters. But again, everyone would still have the opportunity to say, I choose not to speak with you.
Yeah,
But
y'all
they
take
wouldn't
that
be
so well.
prohibited from doing so by the court.
Thank you.
Thank you, Your Honor.
I don't think a lot of them are prohibited.
Let me go to Mr. Radley or Mr. Thompson.
Your Honor, the parties discussed Mr. Logston making his presentation first since it's more substantial.
Okay, Mr. Miller.
I love that the prosecution's like, actually, we don't want to say anything. It's not our turn. Let's just let the defense go first. That was a very respectful way of doing it. All right. We are now hearing from the defense.
Well, we do things a little differently, I guess, of course, because I'm used to putting the evidence on and then we argue. Now I'm a little thrown because we had an argument.
You can go ahead and Ms. Olson can come in and question if she wants.
Okay.
We didn't know until we were kind of halfway through the argument.
Your Honor, we still don't know.
I understand. So, hey, I'd like to start by moving the court to take judicial notice of the press materials that we provided and essentially have the court acknowledge that it has the power to take judicial notice of the press coverage in this case.
Okay, I'll do so over objection.
Thank you, Judge. And then we'd like to call Ms. Jean Saucier. She is available.
The defense is calling their first witness, Jean Saucier. This is a media witness that's going to testify via Zoom. We will see how the sound goes. Yikes. So,
Your Honor, you may have been
Yes.
suggesting this,
Come on
but
up.
may I come back up to
Yes,
this?
come on up
Yep.
so we can hear you.
All right.
I can hear her better back
And
there.
may Mr. Carone come up as well, so if...
Sure.
Ma'am, I can hear you better closer to the camera. I can hear you much better closer to the camera. So these are the attorneys for the media coming up so they can hear Saucier's testimony via Zoom.
I
The noise in this courtroom breaks my head.
There she is. Saucier, is that right?
Was that a dog barking?
Ms. Saucier, could you please raise your right hand?
Okay.
You solemnly swear that
The witness is on Zoom.
that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
Okay, what kind of Saucier do y'all want?
All right. Thank you, ma'am. Could you please state your name and spell your last for the court reporter?
Yes, Your Honor. Jean Saucier, S-J-E-A-N,
Okay, it's a little peaky, but we can hear.
S-A-U-C-I-E-R.
All right. Thank you, ma'am. Mr. Lofton?
Ms. Saucier, how are you employed?
I am employed with a company based in Nebraska, headquartered in Nebraska, called TrueScope.
And what is it that that company does?
TrueScope is a global media monitoring and measurement company. We provide media intelligence data.
And how long
True scope that provides media intelligence. I don't know what that means, but okay.
has TrueScope been doing that?
TrueScope has been doing this for 3 years.
3? Only
The
3?
company that I worked for previously was acquired by TrueScope. That company was Universal Information Services, and that company had been performing media monitoring and intelligence services for over 50 years.
What does that mean, media monitoring and intelligence services?
Yeah, thank you.
What that means is that we, companies such as ours, provide data to corporations, organizations, both in the profit and non-profit world, to show what's being written about or talked about or communicated about their company or other types of maybe projects or things that they're working on in the world. And media companies pull in that data to show return on investment for maybe a for-profit company or other key messages that are being written about or talked about.
And approximately how many clients rely on that service right now?
Currently, we have about 270 clients throughout the world.
And when it comes to how are you able to collect this data? Is it like an algorithm? How does that work?
So it is, there's a lot of technology behind it, but But broadly speaking, the way that our system works is it will ingest content. We have licensed data sources that provide to us content via API. That content is
What
pulled in
licensed
from
content sources?
all media types, from broadcast, print, social, web, and then pulled in
Broadcast,
via
print, social,
API.
web?
And then where that content is housed and stored for the front end of a web platform where our clients can review that data, filter that data, chart that data, and that's how they can see what those messages are and where they're sort of have a gauge on the important content of what they need to see.
And what's your role in this?
My role at TrueScope is I've been with the company TrueScope, previously Universal Information Services, for almost 8 years, and Senior Vice President of Client Success.
And in that position, what kind of knowledge do you have of the way in which the company performs its task of collecting this information?
So I am very involved in the customer support, training, onboarding, client
Wait, you do customer support? Why are you testifying?
demoing. Demos, something that we do to show what the platform looks like, what it can do, the capabilities, the features, functionality. I also
By the way, their website refers to TrueScope as easy to use PR software. So a software company, essentially.
lead the team that provide and produce curated reports. We do that for media insights, and we do that for executive daily news briefing.
And what's your understanding of how accurate the data that you gather and produce is?
Our data is extremely accurate and authentic. We are not, our clients rely on us and have relied on us for a long period of time to have data that's coming from licensed sources, the top data sources that are able to provide that data. And I'm not a developer, so I can't speak to the technical details of the ingestion, but our data and the algorithms that we use to process that data is extremely accurate.
Are you
The algorithm
company a member of any associations? Is there anybody that
they
makes
use.
sure that you're following whatever kind of rules you have to abide by to make sure that you're providing?
There are
accurate
rules?
Absolutely. We are a member of the International Association of Measurement and Evaluation. That's the
The International Association of Measurement and Evaluation. Uh-huh.
leading global, it's called AMIC, and that's the global organization that oversees evaluation and measurement. We also are members of CBES, which is the World Media Intelligence Congress. The president of our North American company, Todd Markey, is an executive.
There's a Media Intelligence Congress?
The VP of PBES at Congress.
Do you know if you have any kind of
I want to go to that meeting.
margin of error for what you guys produce?
The margin of error for media monitoring is really very low, and that is.
Well, if you're just scraping the internet, where would the margin of error be if really you're just scraping the internet and being like, this is what people are talking about? It looks like they are just scraping the internet and being like, your company is being associated with these things. and then they categorize those into topics. Okay. But they're not assigning, it sounds like they're not assigning a value. They literally are just skimming the internet and going from there. All right.
Any margin of error would be as a result of what was published. If something was published inaccurately, we would have that same margin of
So
error.
they don't have a margin of error because they're just
So you don't
scraping
get
the
wrong
internet.
whether or not something was published.
I'm sorry, can you repeat that?
He's asking if ChatGPT is making up the shit that you're talking about. No, he's not. I am.
The fact that something was published and is related to your client's request, you're 100% certain that it's always going to be a story related to that?
Yes, based on keywords and parameters that we utilize from the client to pull that data.
I see. So we contacted you in this case, is that right?
Yes,
And what is it that we asked you to do?
you asked us to begin to monitor content for all media types about this case.
And how did we set that up?
So we set up the workspace or the platform, that's called, and the report.
The
We do
audio.
that internally with our team of experts. But in order to,
So they have a team of experts that reviews the data that's incoming based on a given company. But have you ever done this in criminal? And I think what they're going to get to is something like what we saw in the Johnny Depp Amber Heard case is, what is the internet saying about Bryan Kohberger? I think that's where we're trying to get to. But it doesn't sound like this is normally what this person does. So, but then again, this is a hearing. Here's why we're here. Let's do this for a quick second as to why. Wait, that's not helpful. Why we're here. All right, we're gonna swoop real quick. Why are we doing this? One of the objections by the media was that Kohberger and the prosecution agreed to the non-dissemination order without showing grounds for why a non-dissemination order was needed. And Kohberger's team went, all right, fuck it. You want to know why we're worried? We're going to bring in a media expert to tell you why we are worried about the pretrial publicity. So I imagine that this witness is going to talk about the fact that the weight of the media coverage of this case and of Bryan Kohberger specifically has been negative and could be prejudicial to the defendant pre-trial, because right now this defendant has a presumption of innocence, but the media doesn't seem to be really talking about it that way. I imagine will be the testimony that we are getting. So that is why we are here, so that this person can summarize what the entire internet is saying about this defendant to justify the non-dissemination order. That's why we're here. Okay, let's keep going.
that helps determine the messages and the names tracking, you provided that to us.
Name tracking.
And as a result of that, did you create some, I don't know what we're going to call them, graphs for the court today?
What do we call them? Graphs? Yes, graphs. They're called
And is that
graphs.
what we have labeled as Exhibit A?
Can we see them?
Yes.
Please.
And is everything in that true and accurate as to what it is that you created using the software that your company runs?
Yes,
I would move to admit Exhibit A.
Any objection?
For purposes of this hearing, no, Your Honor, but I would preserve my objections regarding whether this is appropriate expert information. I'll address some of
Fair.
that on cross.
Fair.
Okay, thank you.
Fair.
Mr. Radliff?
No objection.
Okay, anything to respond?
I object. Can we see them? Because we didn't get the
I
motion.
guess I'll wait and hear what the rest of that objection turns into, Judge.
Okay, well, I'll accept that, but I'll admit this for purposes now, the limited purpose that Ms. Olson has described.
So, Ms. Saucier, do you have the exhibit on your screen?
I do.
And is it the same exhibit that was attached to the PDF file, the filing that we did in this case.
Yes.
Can you do a share screen at the first page of that?
Yes.
It really does sound like this Zoom call is coming in from the moon. It really does. Oh, good.
So this is the first page that we see after
Show us the graphs.
Exhibit A that I put on the front of it. Is that correct?
Show me the graphs.
And what is it that we see in this? I guess we call this.
Yay.
slide?
Okay, total volume, total potential impressions.
This is
Let's see what we're going to get.
a
Total,
report.
darn it. Total volume, total impressions, unique authors, metrics over time, key phrases in dataset, top people mentioned in dataset, top organizations mentioned in dataset, top locations, media types. Am I a media type? I think they mean like social media, traditional media, print media. Let's see. So this was the True Scope report. Hopefully this will get filed and we'll get to see it. Look at this photo.
Yes, ordered from the TrueScope platform on June 6th, containing data from November 13th, 22 through
It's a callback.
June 6th, 23. It contains volume, potential impressions, unique authors, metrics over time.
Oh,
key
thank
phrases
you.
in
Thank you,
that data set,
videographer.
top people mentioned in that data set.
Shout out to those Court
Organizations
TV
mentioned in
cameras.
that data set, location, and media.
Can you go to the
Exhibities.
next, page.
Okay.
And what do we see
It's
here?
my exhibities dance.
This is an aggregate total of volume, potential impressions, and unique authors.
This is between the 13th of November and the 2022 and the 6th of June 2023. But they're not saying total volume impressions for what? Because the total volume is only 46,000. The total potential impressions is 2.1 billion. But regarding what? I've got questions. Hold on. I need to take a screenshot of it. I have questions. I need to remember my questions. That's why I'm taking a screenshot of it, because I don't know if we'll ever get this in court. All right, let's keep going.
Between the dates of November 13th of 2022 and the 6th of June.
Yeah, how do you even
2023.
categorize a
What does total
potential,
volume mean?
a Mike could impression?
I'm sorry, can you repeat that? I'm a little muffled.
What does total volume mean?
He's asking what total volume means, but total volume, we haven't quantified total volume of what?
Total volume is an aggregate total of the volume of media coverage for that time period.
Of what?
So that's
Media
every-
coverage of what?
That's every media, for every type that we're tracking.
They have not said media coverage of Idaho, Idaho University murders, Bryan Kohberger. They haven't said total volume of what? They keep just saying of media, but total volume of media regarding what? I'm going to get, we have another half an hour of this. Okay.
And then what are potential impressions?
Potential impression is a metric that shows
Potential, like me,
the
shows potential.
it takes into consideration circulation to show what readership might.
It's literally a Mike Could impression. It takes into account circulation. So if you are taking into account YouTube worldwide, Twitter worldwide, TikTok worldwide, you have billions of users on those platforms. So what do you determine to be reach? Like it's, oh, well, a newspaper has 500,000 subscribers. Not anymore. A newspaper has, 100,000 subscribers. So I guess that's a potential impression. Like they could have seen it because it was in the newspaper and it went to 100,000 people, even though we don't know how many people read the newspaper all the way through. So these are really potential, because she said this is when you take into account everyone who has access. This is This is rough.
What the potential total readership like?
Potential total
So that
readership.
number right there is 2.1 billion. You're telling us that potentially
Maybe.
there have been 2.1 billion readings.
No, impressions are not a reading. Impressions are a maybe.
I think we can probably guess. The unique authors, I take it, is just how many different people have written about this.
Written about
Can you go on to
what?
the next page, please?
Written about this case, written about the defendant, written about what?
What do we see here?
This is metrics over time between the 13th of November and the 6th of
They have
June
still not defined it.
2023 November of 2022, to the 6th of June of 2023. And this is a chart looking at
Okay. We've got social engagement on the one side here. Let me go down here. Oh, no, that makes it worse. Hold on. All right, that's better. We've got social engagement on the side with volume from 2K to 14K. Okay, wait. This graph says, oh, my pointer's still off. On this side, it says volume and then it goes 2K to 14K, but then it says social engagement and goes 50K to 200K. So both are on the same side of the graph. So are we talking about volume or social engagement? I don't know, because those numbers are all different. And then on the other side, we have potential impressions. So now there's numbers running up both sides of this graph. And at the bottom, it has the months. And then in the colors, it shows volume in what looks like kind of blue, potential impressions in what looks like kind of yellow, and social engagement. But somehow they have social engagement. The top line shows social engagement on this line at 200K. It shows potential impressions at 3 billion, and it shows volume at 14K, all on this line. What is happening? And is this just about this case? Is this about this defendant? What is this about? I'm angry with this graph. This graph makes no fucking sense to me. Maybe she'll explain it.
value, potential impressions, and social engagement. Social engagement refers to how widespread social shares are. So engagement, shares, likes, etc.
And why does it drop off? Did everyone stop talking about this
So
case in
based on
June?
We can see that, I mean, it looks like there's never.
It looks like they just made it up, counsel.
Publications of some kind coming out about this case.
That's correct.
Why does the potential impressions bump go way up back in January and has completely fallen off even as the volume and social engagement go up?
The potential impression typically is going to rise if there has been some significant event on a particular day or in a particular time period.
Okay, but why is it precipitously dropped even as all these stories are coming out? Are you frozen?
No, I'm thinking.
Are you frozen? She's like, I just don't know how to answer your question because this isn't really statistical. This is a representational graph of I don't know if it's people talking about this case or Bryan Kohberger or how they determine what was talking about this case or if it was keyed on the word Idaho. I don't know because nobody's ever made it clear. Maybe cross-examination will be better.
I'm not sure that I have a clear answer for that.
Her brain froze.
I mean,
Not
would that
her
tell
Zoom
us
call.
that the stuff that's coming out is the volume of stories increases, that there are fewer people looking at whatever kinds of stories those are?
Objection leading.
Oh yeah, that's fair.
I'm sorry, Your Honor, can you repeat that?
Go ahead. Mr. Robson.
You can answer the question. The question was,
Okay.
We didn't hear subject matter, or at least I didn't. If
The
somebody
question
did,
was-
tell me.
would this tell us that even though there's a lot of stories coming out, for example, in May, the actual circulation of those stories is pretty low?
that would be accurate.
Okay. Can we go to the next page? What is this?
This is what we call a word cloud, and it is a chart that
These are all the key phrases. Look, you guys, it's a words graphic. Hold on. Key phrases in the data set. Let's see. What are the key phrases in the data set? So this is a very big data set. Idaho students, Bryan Kohberger, Ethan Chapin, grand jury, Kaylee Gonsalves, Moscow police, Idaho murders, campus, home, Moscow police chief, Pennsylvania State Police, degree murder, nearby Washington State University, Moscow Police Department, Madison Mogan, Idaho 4, Idaho. I knew Idaho would be in this data set. All y'all, all of Idaho in this word cloud. Knife sheath is obvious, is very small. Felony burglary, first degree murder. I can't read all of that on the side. I paused it. Hopefully it'll stay on this. Latah County prosecutor. It doesn't say Santa after that. Murder weapon. Grand jury. White Hyundai Elantra. Bryan Kohberger's name is small and big, so it pops up twice. Rental home. You're going to tell me that the words rental home are part of your data set? All of this is part of the data set. And you're telling me that the actual impressions of this entire data set, hold on, I screenshotted it. I need a second. I screenshotted their impressions of this data set. Where did my screenshots go? Where are they? Screenshots. There they are. Oh God, my computer has too many screenshots. I need to clear that up. Stat. They're telling me that there are 46,000 total volume. And those are all the words in the data set. That's what you're telling me is no one's really talking about this all that much in the grand scheme of the world. Because if you're telling me that the total volume is 46,000, that's the total volume with only 4,000 people talking about it. And this is your data set. Everything is your data set, including the entire fucking state of Idaho. What you're telling me is that you're really not having that much conversation about this case, that the conversation about this case online is much smaller, or you're just using, I don't know, Facebook. What is happening? And this is, over 6 months with all of these words. I have questions. That's true. It might just be those talking about it in Idaho, but I don't understand because she didn't say that. Yes, Leanne makes a great point. Idaho also has the Valo Daybell case going on. So if you're talking about murder, first degree murder in Idaho, you're not always necessarily talking about this case. That's an excellent point, chat. You're very smart.
we have part of the TrueScope system that shows what some of the key phrases are in any data set with any particular.
Oh, early morning hours. Early morning hours are in the data set. So is guilty plea.
November 13th.
And death penalty.
November.
Between November 13th and June 6th. Hold on, they zoomed in. I'm going to get another screenshot. I will share this on social later. Because I am just kind of floored that this is the testimony happening right now.
13th, 2022 through June 6th, 2023. And what is
it also says old Bryan Kohberger in there.
Showing is what some of the keywords, key phrases that are organically.
Trial dates is in there.
Based on
Idaho AP is in there. Graduate students in there.
Larger wording means that there more, the volume was higher.
Bigger font means they're talking about it more, she just said.
For the larger word are.
Can you go to the next page?
Thanks for the word cloud. Wow.
This one, is there anything we need to know about this that seems self-explanatory?
top people mentions in data set between the 13th of November and the 6th of June. You're telling me the volume of times that Bryan Kohberger's name has been mentioned is 8,000? Because that doesn't seem like a lot.
I think it is fairly explanatory. Again, it's top people mentioned in the data set for that same time period of November 13th through
Can you
June
define
6th.
the data
Again,
set,
it's
please?
looking at all media types.
Next page.
Can you please define the data set?
This is top organizations, same will apply with.
We have more people chatting right now than in this data set.
That we have set up. These are the top organizations or companies that were listed.
And the next page.
Please define the data set at some point.
And same thing here,
Lose
top
my
locations
mind.
in the data set between the 13th of November of 22 to the 6th of June 2023.
And the next page.
Why does Moscow show up twice? Why aren't they correlated? Oh, there we go.
And this is a media type breakdown in the pie.
I'm pausing just so I can get a screenshot of this because we're going to have to reference this later. If this never gets released to the public, I mean, it's released to the public this way. Okay, what do we got? We've got this. This is all the media types. TV, online. How do you define online? TV, online, Twitter, radio, print, Instagram, Facebook, TikTok. The fucking disrespect. Where is YouTube? Are we just generally online? The absolute disrespect. All right, let's keep going. I think, does YouTube count as online? Like, what do you count as online? All right. And it's so funny because if you look at this graph, like Instagram, Facebook is barely a line at the end of Instagram. TikTok, Twitter, and online all seem to be the same color. Radio and then TV. How do you define TV?
Format between the 13th of November
Oh my
2022 to the 6th of June 2023.
Yeah, and isn't Instagram, Facebook, and TikTok all also online?
Correct. With each media type.
And the next page.
Authority figures share a voice. I need to know what this means. But at the bottom, it says Idaho state coverage, Mayor Art, somebody, FBI, Moscow police, Latah County prosecutors. And then it goes on to say a bunch of names that are covered up, including Ann Taylor and Shannon Gray. And then at the end, there's like David Nye, not Bill Nye, the science guy, and others. So I'm interested to see who the names are at the bottom of the graph that are covered up by the I did that badly, that are covered up by the Zoom thing. So, oh boy. Okay, let's continue.
All right, well, so it's the one that everybody wants to talk about. Can you give us an understanding of what it is that we're looking at here?
WTF is this?
Yes, this is a chart that our media insights team created based on the content that we exported from the TrueScope platform into a CD, Excel file, PDF, and then charted it on the graph, and it is showing the content for each authority figure and what we call share of voice, so that's volume and impressions, and that's showing the time period of 11/13 of 22 through 4 of 23.
Can you explain the share of voice a little bit better?
Please. Can you please explain what the fuck is this? And what does this show? What are you trying to show?
Sure.
How do you know? I mean, it makes it sound like,
I didn't even bring snacks.
for example, we're talking about
I didn't think today would be this extra.
They get to talk, I guess,
What are you trying to quantify? Oh, wait, there we go. Names.
Sure. So what this is showing, the Moscow police, let me pull this up a little bit more. So the Moscow police have the highest volume in the data set, and then we put that number in that data set, and the volume is in blue, and the potential reach is in the dark.
Double rainbow.
It's purple, but it looks more blue
What does
here.
it mean?
So the Moscow police have the highest volume in the data set. That meant that they were featured or quoted or somehow listed in 20%.
The poor camera operator is trying to figure out how this matters and just is like, what is happening?
1,585 stories. With that, they have the largest potential reach, which is potential impression.
They have
And
the Moscow police have the largest potential reach. And
you see over to the right that we have potential reach listed on the right-hand column side. And so that is at almost 62 million impressions. So that means that and I'm not, I don't know that you want me to interpret the data, but this is an aggregate look at
data from what?
how far the potential of the messaging from each of these
I don't know how the court bases a ruling off of potential, because the court can really only base it off of what's happening. So now we're in this world of potentiality, which is really tough for the court to use and put weight on because it's potential.
main animal organizations went through the data set.
And to the extent that you have listed David Nye instead of Jeff Nye, is that our bet?
We did not change any of the names that you provided.
Okay, next.
We did not change any of the names that you provided. Did you hear that? She just said, we did not change any of the names that you provided. So who provided the data set? This is giving all of these hashtags are negative because I was told all of these hashtags were negative. So we just made all of the hashtags negative. Who provided the data set then? Because isn't this supposed to scour the internet and see what comes up in relation to conversation? Or is it just the defense saying, here is the terms that come up in this case, can you quantify them? And then if that is it, oh gosh, okay. So the data set is really the defense's data set. Okay, fine.
Please.
It's giving Depp v. Heard vibes. I mean, that's appropriate. It's a year out from Depp v. Heard. We had to get some kind of random experts trying to quantify a thing like the internet. I mean, how do you quantify the internet? Somebody asked ChatGPT. How does one quantify the internet? Why does this say at Skippy45? These are non-authority figures share a voice. Oh, I can't wait. Who is at Skippy45? I can't wait to see who the non-authority figure share of voices are. And were these names given? Hold on. That's not what I meant to do. Were these names also given by the defense? Also, don't tell Jennifer Coffendorfer that she is a non-authority figure. Rude. Ooh, hold on. All right. Who gave these handles? Because down here at the bottom, it says at 2-for-1 chum gum hearsay, exclamation point. I have to take a picture. At 2-for-1 chum gum hearsay. What is happening? Also, at Victoria 46453259. And what do you mean by volume? And why does one side say volume 0.2K and the other side says volume 43 million? What? Are we being trolled in a court hearing? I feel like I'm being trolled. Don't Google. Don't Google. I don't know what's happening. So by non-authority figures, they mean randos. Yes. Internet randos. I can't with this chart. Did the defense give them the name? Are the new internet randos at Skippy45, at Lady Digging, and at 2-for-1 Chum Gum Hearsay? Mark Levy is an AP reporter. Okay, so Mark Levy, the AP reporter, Rebecca Boone, the AP reporter, and then Victoria 4645-8675309. Sorry, Victoria, I've renamed you. Skippy 45 and 2-for-1 Chum Gum and Lady Digging. Okay. Who gave them these names? Okay. We're going to keep going.
So this is essentially the same thing. Is that right?
Oh, no, this is not the same thing at all. It says, what is Chum Gum?
That's correct.
And in terms of the concept of...
Oh, these are definitely Twitter users. But I have to wonder if all of these are... Some of these are probably Anon accounts, right? When you're looking at 46453259. Like, really? However, to all the Twitter users that just showed up in court, congratulations to you. I know that can be a big moment in anyone's online journey. So, cheers.
Versus non-authority, where did that come from?
Authority versus non-authority came from that.
I guess what she said came from...
Me, Judge.
Oh, you. Okay, thank you.
Yes.
Next page, Judge. I mean, sorry.
These are literally random Twitter users. Yes, these are the randos of this case, apparently.
And this is just another slide.
Share of voice media coverage. What does that even mean? Is that just the volume at which they tweet? Is that the volume of which their names are in it? What does that even mean? And again, on the one side of the screen over this way, on this side of the screen, you have potential impressions that go up to 545 million. But on the other side, you have actual volume at 1,000. How the fuck do you correlate? I'm sorry. I am not sorry. How the fuck do you correlate? And I need someone to explain to me. How do you correlate a 1,000 actual volume to a 545 million potential impressions? How? What is happening in this chart? I need all the explanations. I am ready for cross-examination. Can we get to cross-examination? Because then maybe I'll understand. Oh, that's the wrong way. That way.
Hearing. Mr. Gray. Yeah.
So this slide, your office asked us to prepare for the particular link to do a share voice chart showing where each of them fell in the data sets and on the chart.
Is that the last page? Are we done yet?
The attorney said, is that the last page? Are we done yet? You have the graph in front of you, sir, but also relate. I feel the exact same way.
Then we have a chart.
Ooh, methodology, key terms defined. Hold on. Key terms defined. I'm going to read this so we can talk about it real quick. Authority versus non-authority figures. Authority figures are experts who are currently working on the case. Non-authority figures are experts who currently work in or formerly worked in the field of law enforcement, law, but who are not working on the case. So chum gum is not a rando. It's someone who works in the field of law enforcement, police or FBI, law, such as lawyers or other court-related personnel, but who are not working on this case. So chum gum is a lawyer? Wonderful. Data collection. Data presented was collected over the specific time period across mainstream media, including newspapers, television stations, radio stations, and website. Additionally, social media content was collected from Twitter and Facebook. Oh, just them? Just Twitter and Facebook? You chose the relevant stuff that, okay. Impressions. Circulation, but also you didn't tell me what the data set was, but circulation/impressions should be considered as opportunities to see a story and not the actual number of individuals who read or viewed a story. One person can have many opportunities to see a story and be influenced from several different mediums: TV, radio, print, web, or social. Volume, aggregate totals of stories as seen across all media types. Measurement methodology. All media measurement is designed based on agreed upon objectives from the client. Our methodology adheres to the Barcelona Principles 3.0 as advised by the International Association of Measurement and Evaluation of Communication, the AMCE. Metrics used are either provided by industry standard services or are proprietary. Are you going to define which? And have been developed according to their statistical significance and are replicatable. Full data of all found stories and calculations are available to you, as measurement transparency is crucial to reliable and valid data. Narrative explains what the data represents or provides inferences taken from the data. But how? But what media? Like, what were you? How were you defining that things were related to this story, though? Because that has not been defined. Maybe we'll get there. Emily, keep reading. Let's just keep reading together. Great.
Okay.
Great.
All right, well, I don't believe I have any other questions for you.
I
but
have
we may get
so
some
many
from
questions.
Thank you.
Hey,
Thank you, Mr. Robston.
Remember, I have a hard copy of Exhibit A. Does the court want that to place in the record?
Yes, please. I'll be admitted. Defendants A. Mr. Rudley, do you want to weigh in at all?
We have no questions, Your Honor.
Okay, Ms. Olson.
Thank you, Your Honor.
Oh, I'm very excited for this. This is the cross-examination from the Media Coalition attorney, and I bet she is full of questions about this. Hopefully we'll get some basic answers like, what's the data set? Like, how did you decide that things were within or without the data? Okay.
Good afternoon, Ms. Saucier. My name is Wendy Olson. I represent the intervener media.
good afternoon.
Ms. Saucier, where are you coming to us from?
Do you need my location?
My office via the internet. No. What state?
I'm in Chicago, Illinois.
And when did the Kootenai County Public Defender's Office hire you for the work that you've done in this case?
The first day of our agreement was February 15th, 2023.
So February the 15th of 2023?
Oh,
That's correct.
And in all the data that you've shown here in court and
they hired the PR firm back in February 2023. That's interesting. I need to go look at when the Supreme Court denied the motion. Was this ahead of that? I wonder.
are in Exhibit A, I know that starts at November 13th of 2022 and goes to June 4th of 2023. Why did you start with November the 13th of 2022?
Because that is the date that our client asked us to begin searching.
So the date the defense asked.
We were able to pull in historical content previous to the agreement or the date that we started searching for media type.
And I apologize, Ms. Saucier, but the copy of your report that I have, it's Exhibit A, doesn't have any page numbers that are in it. But if you could
Oh,
look
God.
at, I mean, let's just
Anyone who needs to give reports to court ever, page numbers on everything.
pick the one that is, no, metrics, well, let's start with the first one, I guess it's page 2 of Exhibit A. If you wouldn't mind putting that back up, ma'am, so we can see it here in court.
Sure.
I'm real excited about this cross right now.
And right there.
It says page 2.
Yep. No, sorry, the one above that, the first thing is total volume, 46K.
Explain, please.
All right, and this one, is there any way that we can tell from this slide how much of that volume occurred from November the 13th of 2022 to December 30th of 2022?
No.
Not from this slide, no.
And is there any way we can tell from this slide how much of that total volume occurred after January the 13th
I'm in the way.
of 2023?
Not from this slide, no.
And then would that be the case for all of those slides? If I'm looking at anything in Exhibit
That should be the question. Ma'am,
A,
could you make this make
The only thing that tells
sense?
us is what happened over that large period of time, and it's not broken down by date set, correct?
From this slide, it is not broken down.
Yeah, and so if we go to the one
It's
that
from
says,
the other but
I apologize. And for the one that says authority figure share of voice, and again, I don't have the pages, so I apologize. And that one there that says, Moscow police and is just under 25,000, you can't tell us how many of those were before December 30th of 2022, how many were after that, how many were before January the 13th, and how many were after that. Is that correct?
not from this slide, that's correct.
And Ms. Saucier, when Mr. Logston asked you the question about David Nye, I assume you don't know who David Nye is, correct?
No.
If you mean personally, no, I do not.
Well, at all, do you know who he is have you learned who he is in the course of all of this?
I don't know who David Nye is.
I did not spend a lot of time looking up or researching any of the authority figures or the non-authority figures.
You just took the information that Mr. Logston provided to you, is that right?
That's correct.
And so you have no idea of knowing whether in fact the person is an appropriate person to include in the data set as an authority figure or if they're not. Is that fair to say?
We utilized the name that we were given from our client
And you,
based on their.
I'm taking another screenshot. They're talking about David Nye a lot, so now I'm real curious. That's, I guess, research after the stream. This is really interesting. It's a shit show, but it's real interesting.
Knowledge and expertise.
and do you have, as some of the information that you prepared, is there an addendum anywhere where we can look in order to evaluate your information at that list of names that were provided to you by Mr. Logston?
Yep. Did they provide you with all those social media handles, or did those just come up organically in your data set? That matters a lot.
I'm not sure that I would have the authority to
Release that
provide that.
information.
Okay, well that's data that you used in your analysis, right?
That's correct.
And with respect to this data set, what do you mean by that, the data set? What is that?
The data set is the volume of coverage that is in our system based on the dates that we have filtered for.
So all media, yes, Trev. I'm still streaming. I'm not going to be able to hear you because nonsense that's happening in court. Ways you never should do your homework is happening in court right now.
Just to remind you, we have to pick up cheating
Thank you. Thank you for keeping me on time. Dad wanted you to check in to keep me on time. Thanks, buddy. Bye.
So,
I'm going to rewind a little because I got distracted. Okay. It sounds like you're okay, bud. It sounds like they're talking about all media coverage. All? They're not defining this data set really well.
the data set is the volume of coverage that is in our system based on the dates that we have filtered for. So in this case, for these slides, we filtered 11, 13, 22 through the dates that we created these each particular chart. In this case, June 4th, 23, to get the most accurate data set, most up-to-date data set.
All right, but what's in that data set? Is it a whole bunch of, like, is it 20 different media sources that you run search terms
Good
against?
questions.
And then somewhere downloaded is all of the stories or whatever you want to call them that come back when you run that set?
So in the platform for the workspace that we have set up for our clients, all of the content that we have ingested since we started working.
All of the content we have injected. What, into their system? Oh boy. She said the data set equals the volume of coverage in her system that she has filtered. Yeah, it's a non-fucking answer. Yeah, it's just a non-answer.
With that client, and this is the case for any client, any coverage that has come into our system that has been tagged, for lack of a better word, to
Covered
try to
what?
explain it, that has been pulled into our system is in a platform, a workspace, a web-based workspace, and we have access to pull all of that data or to filter based on a name or organization or any number of many other filtering options.
Okay, I'm still, I guess maybe I'm just not understanding how you get the data set. So is it, like, let's say on November the 13th of 2022, somebody ran a story about a
Yeah, that's what they're
911 call
asking.
made to the Moscow Police Department, and it runs in, and it's an Associated Press story, so it runs somewhere initially, and then it gets picked up by a bunch of other people. How does that get captured in this data set that you're talking about?
So how that gets captured into this data set is through the front end of our system. That data resides and is housed and stored. And so let's say it was an AP story that is in, that has fulfilled the parameters that we're searching for. That story will be in the workspace, in the platform, and we're able to pull that based on filtering parameters. Let me try to explain it a little bit more clearly.
It's in the system because it's in the system. Okay.
And are you looking at something, ma'am?
Pardon me?
Are you looking at something that you're trying to
Oh.
provide an additional explanation of what this is?
Ma'am, I am very much enjoying this attorney's cross-examination, as is this attorney, it seems. And now that she's not turned directly to the court, she's much easier to hear. This is really interesting.
So we use the front end of our platform, which houses the data that's pulled in from the back end of the platform, and that data is pulled in from our data sources, ingested in a number of different ways, primarily API feeds.
And so is the data like a news story about, that they've given you one of the terms?
Yes.
Okay.
Yes, so it's the published content. I'm sorry, maybe I wasn't clear about it. It's the published content.
So the actual story would be there, is that right?
That's correct. That's correct.
And for whether the actual story is in there, to put these charts together, you went through and just
Wow.
basically counted and how many of those stories certain terms appear. Is that right?
That's correct.
Okay, so there's no effort to like qualitatively examine what the story has.
They count how many times the terms pop up in their data in the media coverage. So the amount of time Kohberger's name's mentioned could be 10 times within one story. Does that really give you a sense for how vast the media coverage is?
And it's simply a counting exercise about how many times certain terms appear in the various media sources that get ingested into your platform. Is that right?
Yes.
Ingested.
In this case,
She said ingested into the platform. Okay. The platform just takes it in.
and in many of the cases for our clients, we are looking at quantitative total versus qualitative.
And a lot of times, it's because you want to see what sort of phrases your clients want to see, what sort of phrases are catching on with the media, right?
Yeah.
There could be any number of reasons for doing that.
Including that, right? You know, if you have a new like slogan, someone might hire you to see, hey, is our slogan being picked up on Twitter or those sorts of things? Is that right?
That's right.
Okay. And that's sort of where that idea comes around for that word. I forget what you called that, the word thing, where some of the words were bigger than others.
Correct.
Yeah. And so, Ms. I have a few more questions for you, Ms. Saucier.
Oh, ma'am, I need more than a few
Sure.
questions.
So with respect to these charts we're on now, this authority figures share of voices, the next one is a non-authority figure share of voice, correct?
Correct.
And you said that that's a term that came from the Kootenai County Public Defender's Office, right?
That's correct.
Yeah. And so that's not a term you ordinarily use in the work that you do through TrueScope?
That's correct.
Okay. And it says that, and I read your definition, and it must be the one that was provided to you that's on, it's not on that page, but it's two further, and it says non-authority figures are experts who currently work in or formerly worked in the field of law enforcement, police or FBI, law, such as lawyers or other.
She's asking about the non-authority. Please ask about the Twitter handles. Please, 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 please ask about the Twitter handles.
Related personnel who are not working on this case, correct?
That's my understanding.
Yeah, well, that's information that was provided to you, right?
Correct.
And so you didn't like use really any expertise there. You just used the definition they gave you and counted some stories that had these names in them. Is that right?
She doesn't know.
I'm not quite sure how to answer that question.
Okay. Well, let's back up to the one that says non-authority figures share of voice.
This attorney's cross-examination is great. I am very here for it.
Now, the one above that. Right there, yeah.
Chum gum! Chum gum!
Right there.
That one!
And the person that has the highest number there, and I guess there's this other line that talks about potential impressions, I'll come to that in a minute. But this line that says Rebecca Boone, AP reporter, I take it that's information that was provided to you by the Kootenai County Public Defender's Office as well, is that right?
That's correct.
Yeah, do you know,
However,
do you know?
however,
Go ahead, ma'am.
as we're looking at media content, our platform pulls in the content and also takes us to that original published story. So we are able to see if something is written by a reporter, such as what's the case here for Rebecca Boone.
Okay, but my point, so she's an AP reporter, but she's not, as far as you know, someone who currently works in or formerly worked in the field of law enforcement, correct?
Bing, 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 bing.
I do not know anything about her background.
Well, would you agree with me that if she's never currently or formerly worked in the field of law enforcement, law,
She doesn't meet the definition of non-authority figure.
that is not working on this case, she would not fit the definition of non-authority figures that you used in your analysis.
Accurate. Get it?
That's correct.
And
I hate this chart so much that I'm living for the cross-examination.
Did you do any sort of quality control on this, Ms. Saucier, to determine whether in fact the individuals listed here?
This attorney's like, Miss
were,
Saucier, seriously, what the fuck?
Persons who currently work in or formerly worked in the field of law enforcement?
I did not do background
She's like, no, I just read the data.
research on.
Hold on, we need to talk about this real quick. I do not want to be on the list. Chat, keep asking. I see you. It's not just you, Kristen. I see a lot of you. Why is Emily not on the list? Emily doesn't want to be on the list. Emily never wants to be on the list. Emily doesn't want to be in the data. Also, they didn't consider YouTube. And I don't tweet that frequently. Emily doesn't ever want to be on the list. Emily never wants to be on the list. Ever. I just want to do my thing over here. But they didn't consider YouTube. So there's also that. But this attorney wants to be like, so Ms. Saucier, what the fuck did you actually do? And what is this? Did you just like, you just counted up names that showed up in articles then? Great.
The names that we were given from our clients, nor did I do background research on names that appeared organically in the data set.
No background research.
Uninstructed.
And so you didn't check whether or not any of these people actually were currently or formerly working in law?
Please, counsel for all of us that have gotten over an hour and a half into this hearing in court, please, for the love of everything, ask, so you didn't check who Chum Gum was? Please let it happen. I need that moment on the record in court. No! Please!
I did not do a deep dive into anyone's background.
Including Ms. Boone's.
Chum Gum.
And Ms. Saucier, would it be fair to say that, there's a number of journalists here in the courtroom today, and that if they all write a story about this and talk about your presentation and indicate that
where's Chanley Painter?
In your chart referred to
Why is she
Ms.
not on the
Boone,
list?
And that I ask you questions about Ms. Boone, into your data set are going to pop all of those other stories, or stories that refer to Rebecca Boone. Is that right?
Can you repeat that question?
Sure, it was kind of long. It's a bad question. So, Ms. Saucier, there are a number of journalists here in the courtroom this afternoon.
Who are not on the
If
list.
they all write stories.
Why did they not make the
about this
list?
hearing and mention that there were slides in your presentation that referred to Rebecca Boone, and you were asked questions about Rebecca Boone. Those stories they write that refer to Rebecca Boone would then pop up in your data collection that your firm is doing for the Kootenai County Public Defender's Office, correct?
Stories may pop up, but based on volume, they wouldn't necessarily have a very large share of voice if we were to be charting for looking at them from that path.
My question was just whether they would pop up in your data set.
They would pop up in the data set if it was about the case, yes.
Would they?
And you're familiar with the Associated Press, I take it, Ms. Saucier?
Yes,
And you know how they work. A reporter for the Associated Press may write a story in Moscow, Idaho, and once they put it up on the
It just
wire,
goes
that
everywhere.
could get picked up in all sorts of exciting places like Des Moines, Iowa, where I went to college, or let's say Crete, Nebraska, right outside of Lincoln, or any of those places, right?
All kinds of exciting places.
And they might run,
Like
because
Des
they run
Moines.
in a different publication, they're going to be counted as a different story. Is that right? In your data.
This attorney, can you see the difference? Chat, I know a lot of you have been here with me for 3 hours. Can you see the difference in this attorney's style between arguing to the court and cross-examining the witness? This attorney has been a trial attorney for a very long time. And this is a very good cross-examination on Your Honor. We didn't have a whole lot of time to prepare it to... Let me ask you questions. This is what this attorney does.
correct.
Ms. Saucier, I have a question about, I think it's on...
Ms. Saucier, I have a lot of
It's the
questions.
second page of your exhibit B. And is that in evidence?
He's not.
All right.
We
well
can
then-
put it in evidence.
Yeah, well, it's submitted to the court. So I don't mind offering exhibit B. Do you have that with you, Ms. Saucier?
I would move to admit B. Okay, no objection?
No objection.
No, I thought I was offering it, but that's all right.
You are, well,
Okay.
okay,
Anybody who wants to offer it can offer it.
all right. It's a dual offer.
Great.
I'll accept that.
What's Exhibit B?
All of Exhibit B. And so I apologize, Ms. Saucier, and I know it's late in the day, but your document was upside down. So is there any way you can turn that so?
Yep.
All right, so if we go down to, on the second page of the text of Exhibit B, it says impressions. And you recall discussing that term when Mr. Robinson was asking you questions?
Yes,
And so you say here that circulation impressions should be considered as opportunities to see a story, correct?
that's correct.
And not the actual number of individuals who read or viewed the story, correct?
Yes,
And so there's no guarantee whatsoever on any of the potential impressions that anybody read the story, correct?
Ding ding.
that's correct.
They're just
And there's
impressions.
nothing that any of this that tells us that what was in the story, correct? Other than maybe these terms.
Can you repeat that question?
Sure. And there's nothing in any of what you've provided to the court that tells you what is in a story other than the terms that you were asked to search for. Is that right?
I'm sorry, it's a little unclear on what you're asking.
Sure. And the data set that you gathered, well, strike that. In the exhibits that you put together, Exhibit A that you testified about, and then Exhibit B that's on the screen now,
Y'all, here's your opportunity to like the stream. YouTube, I swear I have 4 billion impressions. It's the potential, right? We could just make up the numbers.
there's nothing in that that tells us what the substance of a story is other than it had certain terms in it,
Nothing
correct?
has told us what the substance of anything is. This is wild.
Ms. Saucier, have you ever testified in court as an expert before?
I personally have not, but others in my company have.
Nope.
And with respect to this particular exhibit, and thing, what work did you do on this project?
I filtered and collected the data that we utilized in share voice charts, and I also produced, filtered, collected, and produced the first part of the chart that I produced on the platform. So,
Yeah. And then what, if any, sort of quality control was there done to determine whether or not you pulled
These are great
the
questions.
data accurately?
Andrea Burkhart was in court for this hearing. I'm sure she streamed about it because this hearing is Friday.
I'm trained on the platform. I know how to filter through the data, and I filtered through that
Imagine.
data accurately. The data,
We've just filtered the data.
the
Why?
parameters that were in the keywords and search terms are set up accurately.
She didn't even ask if she was
so
board
that gives them
certified.
accurate
Rude.
results.
And have you ever used Westlaw, Ms. Saucier?
Not personally, but I'm familiar with, and I know what it is.
Ma'am, have you ever used ChatGPT to create a word cloud about Bryan Kohberger? I'm going to ask.
So is the process you're describing sort of similar to running a search in Westlaw and then you get a certain number of hits and you know that that search term actually produced those number of hits because that's just the way the software works?
Similar. There's a little more to it than that, but that's a decent summary of how our systems, our software may work.
I have just one moment, Your Honor.
Yes.
I think she's probably almost done. This hearing's almost done.
All right, thank you very
Ivan.
much, Ms. Saucier.
Yeah, she's
All is
almost
well in Chicago.
That's
Thank
very,
you.
I hope all is well in Chicago. All is not well with your fucking graphs, and we still don't understand your data set. The data set is all media that came in to the data set is the data set, and then it's filtered, and then we pick words out of the sky that are given to us. The words are picked by the defense. Oh boy. This is going to be real interesting. We've got a few minutes left. Not even.
You're not seeking any questions, Mr.
Mayor, on
Mr. Dudley is saying no. Anything to follow up? because then we're going to take a break.
This is only part
Follow
one.
up on any questions there?
No follow-up.
We're good, Jeff. Okay, excellent. Thank you, Ms. Saucier. You can be excused. Hello?
Hello.
I'm getting an echo somewhere. Okay, from you, Ms. Saucier, you're excused. You can stay on if you want, but you probably have other things to do. So thank you for being here today. We appreciate your answers. So.
All right. And that is the end of that. Let me see if there's a part two. I don't know if we're going to have time for a part two. I don't even know if a part two is available, but there should be a part two. I'm going to try to speed run some questions. And if I can find the second part of that hearing, then I will pull it for, let's see if I can find it. If I can find the rest of that hearing, I will pull it, but I don't know if we have the rest of that hearing. Oh, there it is. There is another 30 minutes left. Unfortunately, I have a meeting, so I'm going to have to finish the last 30 minutes of this on because I have a meeting in like 15 minutes. So I'm going to have to finish the last 30 minutes of this on Thursday. And then on Thursday, I was going to ask you, and we can take a poll on this. I asked in Patreon, and what a lot of you said was that you were interested. Do you want me to cover the Corey Richins Utah alleged poisoning case and the hearing for that on Thursday? I didn't mean for it to be a part two. I didn't think there was another 30 minutes. I thought that was the whole hearing, but there is another one. So I guess this is a part one because I absolutely have to hit my meeting in like 10 minutes because it's a busy week before I leave for VidCon. A lot of you guys see that you want Richins cover. I will put that poll up on my community tab. Let's take just a minute and do I have questions, you have questions, we have questions, and then we will do both court hearings on Thursday. Sorry to give just a part one. Maybe by Thursday we'll have the court's ruling when we get to cameras in the courtroom, hopefully. Emily, you shouldn't have done quick bits. We shouldn't have talked about Girardi. I know. I have a really hard time planning. But I looked at the time. I was like, oh, it's an hour and 30 minutes. We can get through it. And then there's another 30 minutes because I split them into two videos. Oi, I tried. Streaming is hard. Some days we just do our best. Octo, so good to see you in the chat, friend. And a huge thank you. It sounds like, well, Octo would know because Octo's looking at it. So thank you all for supporting the Pride launch at lawnerdshop.com, where you can get our new Lawnerd designed tumbler and a few other goodies if you want to, and support not just this community, but the LGBTQIA plus community, also our donation partner. The voices seem to be where the articles and posts that were looked at are sourcing their information. Maybe, but they didn't actually say that. Stephanie, you've said that better than that expert did. They should pay you the big bucks. Leanne said, actual legal question about the relevance. How do any of these words, other than Bryan Kohberger's name, prejudice any jury against him and violate his rights? You're not wrong, Leanne. This is the defense showing how much media there is surrounding Kohberger, but I don't think you needed this expert to show that. If you're not going to try to show that, hey, most of this media coverage is connecting his name to negative things, the fact that there is pretrial publicity is not the question here. Yes, there's pretrial publicity, but is that prejudicial to a potential jury pool? And this expert has not shown that for me at all. Like, it's a no for me. Let me know how it is for you, but it's a no. It's a big no for me. This feels like the old Social Blade stats on channel ad revenue. Like someone is allegedly making between $4,000 and $9,000 per month, according to Social Blade, even though AdSense says $3 of lifetime earnings. Michael, that's an excellent point. It's just like, the numbers, we're going to embiggen them. we're going to enlarge the numbers here. Elizabeth said, to be devil's advocate, it could be that the data in revelation to the victims, he had 8.8 thousand to each of the victims, 11K. That's higher in relation. I don't know, because the expert didn't explain what the numbers meant. Throw darts at a board and then draw some graphs and stuff in 58 pages for the first section. Grand jury is a search term. This is an embarrassment. Grand jury was apparently one of the data set terms that came up because the data set went through June and that grand jury happened. But the fact that a grand jury is being discussed isn't prejudicial. At this point, I'm surprised the data set didn't contain the word potato. Potato. Same. I don't think it's fair to argue that the media coverage is prejudicial while simultaneously favoring that a very broad non-dissemination order stay in place. I think that's a fair point for the court, because the court's like, well, if it's prejudicial, well, then allow people to answer it. I think that's a very, very fair point. Stephanie said, question, so will anyone be able to cross-examine her? We just saw that happen by the media, because this is the media's motion. Why interviewing her and not like KXLY in Spokane? I have no idea. That is the media person that was hired by the defense to show the media coverage, or the breadth of the media coverage, I guess. Lindsay, congratulations. Good luck on your interview. Thank you so much for buying my book. You're welcome. There are way too many variables to these stats. This is ridiculous. I'm frustrated. Lynn said, I aced my ACT watching this channel. Well, I'm glad we could help. Sometimes the words we use are not real ones. So note of caution. Do we know when the judge is going to decide? The judge has not decided yet. I'm sure we'll know the second the judge does. We'll have to go follow Chum Gum on Twitter to figure it out. Please explain, Emily, why are they protecting this case and defendant like this? Is unusual. Like, this is unusual for social media and the public to talk about a case. There's always talking about every case. I think this is maybe particular to Idaho because it's not just this defendant. This is going on in the Vallow Daybell cases as well. I think this is particular to Idaho. I don't think this is particular to Kohberger. So if that helps, Idaho seems to be a little bit more particular about their media coverage. Linda Fry asked, when will we cover the Bland Richter memo response with lots of golf references? That's on tomorrow's podcast episode. The members got to see my thoughts on that when I recorded it yesterday. I'm so in love with the lip glosses. I'm Japanese. Hearsay colors like coral. Objection is like fuchsia pink. And you said it's not sticky at all. It's not sticky at all. Hearsay, for me, does not color like coral, but I'm glad. I'm glad you love them. Yay. And congratulations. It's all very strange. Alta Spaces, as a data scientist, I would have done this completely different. I bet you would have. They were just going for like vibes. Like the charts are like, people talk about stuff. Because stuff. If you don't give the internet facts, it will make up its own facts. Nefertiti. Facts. That's exactly what it is. Because there's nothing to argue it with. It's just a bunch of speculation. And you can't point to something and say, actually, no, it's this, because it's nothing. It's speculation meets speculation. Danita said, everyone at the dentist loves my objection lip gloss. I'm so glad. I love it too. Why is he waffling so darn much? Seems like he's just playing lawyer with her. I think this is referring to the judge from Emily from earlier. And the judge is having a chat. The judge wants to discuss. The judge wants to do a Q&A. The judge wants to ask you questions and have you answer them. This is probably how I would be as a judge too. I have questions. Tell me this. What about this? So the judge is engaging in questioning. Not all judges do that way. Some do. Thank you for the welcome distraction entertainment, keeping me company on a day when I want to quit my engineering job. It's killing me. Kara, I've been there. Some days are like that. It's not just you. Take a deep breath. Try to get some rest. Hydrate. It will get better. Dr. B would be a great juror. He would be. He follows nothing pop culture. Are we going to cover the Corey Richins case? There was a hearing yesterday. I'm going to put up a poll on the community tab. I asked the members. The members are here for it. So maybe the reason I am not covering any trials right now is because I have a bunch of travel coming up, and I don't I did not love the experience at Deputy Heard of getting into the trial, then having to travel, and then coming back to the trial. So some of what I'm covering right now is trying to catch up with stuff we missed during Murdaugh and Paltrow, and trying to make sure that we have things that we are covering going forward and are going to stay covering and get caught up on our old coverage. So I know there's other trials going on right now. It's a balance to try to cover things that also work with summer. I don't want to get into a trial that's going to take us weeks and weeks when I have travel coming up, because then I'm going to get a million of Emily, you left us. And I know. So I also don't want to jump just into cases that I know nothing about. So catching them at the beginning sometimes is helpful. So that's part of it. I know there's trials going on right now. I just don't have the bandwidth with being gone all of next week to cover any trials right now. Emily, is it just a judge's style choice to provide written orders and decisions rather than making them on the record? Yes, it is. And in high profile cases, judges seem to want to think about it, and I appreciate that. Did you ever have a case with the non-dissemination order? No, I didn't. But I didn't do I did one high profile. Well, I was associate counsel, co-counsel on some higher profile cases, but even in those cases, there weren't non-dissemination orders and no one had asked for them. After a long struggle with my neurospicy brain, I finally graduated university. Congratulations. And thank you. I try to be open because I think shame is one of those things, especially when we're neurodivergent. Shame keeps us really quiet. And I don't think there should be shame about operating different. I mean, people aren't ashamed to be allergic to stuff. People are like, oh, I have celiac, or, oh, I'm personally allergic to tomatoes, or, oh, like, why is there shame when our body works different? Or like, there's no shame when you break your arm. Generally, it's like, I fell and I broke my arm. I mean, sometimes it's like, well, I went roller skating drunk and that was not a good decision. But I'm thinking of Real Housewives, not me. But generally, there's not shame around these other things. So why would there be shame around neurodivergence? But so often there is. And I don't think there should be. And the more we talk about it, the more we normalize it, the more people learn to understand, like, hey, we operate differently, but that's not a neurodivergent thing. That's a human thing. All humans operate differently. And when we can share that we have different experiences and different points of view and different outlooks, I think we can all find commonality. And I love that. So with all of that, y'all, I have to go. I have literally 2 minutes to run to the bathroom before my meeting. So I have to say goodbye for now. I will see you Thursday. New podcast out tomorrow. Members only live stream is coming up this week. I will put it in the members spaces. If you are not a member, now is the time, because it is going to be a lot of members behind the scenes while I am at VidCon. So the members only live stream, I am going to move to Friday. I'm going to put all the times in our spaces. My mods are like, this is the first we're hearing of it. I'm sorry. I had to book an appointment on Wednesday that I had to get to before I leave for VidCon. So members only will be Friday. It will be during the day because our members only is supposed to be midday this week. So instead of Wednesday, it will be Thursday. So there's plenty of time for you to become a member, and hope that you get gifted a membership. I will see you on the podcast tomorrow and back live to cover court hearings on Thursday, and members only on Friday. So with all of that, it is time to say goodbye. You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.